filed. When the matter will be taken up for hearing, it will be without the opposition. Yes, call the
Lordship,
list.
kindly it be listed.
Yes, call.
I am for the petition.
Yes. Yes, yes. Why it is appearing under the heading to be
That
mentioned?
was the direction of the last 11th of March. No?
Yes.
11th of March, there was a direction, my lord. They filed report. I was asked to file a, my lord, exception to that report. I am filing the same. I have already served copy upon my learned senior.
Yes. What is the matter?
Our matter relates to DRT.
Yes.
But one, when there was no DRT bench at my lord Siliguri, this was being taken up at Calcutta.
Yes.
Now, after constitution of this bench, my lord, that was transferred. A person was entrusted by the then my lord defendant to appear. He expired.
By the then defendant,
Yes.
bank,
No.
private party.
Borrower.
Borrower.
Borrower. Who are you?
I am for the borrower. I am for
Borrower is the defendant in that proceeding.
that proceedings.
Yes.
Now, in 2017, that person was entrusted to enter appearance. 2018, the defendant expired. Now, subsequently, enter proceeding was complete against us. Now, when an order was passed, we got certified copy. We came to learn that one Piyushana Chakraborty filed 3 applications. One is substitution application, another is my lord condonation of delay, and third is put up petition.
She appeared for whom?
Now, it was recorded in the first order that on behalf of the bank, but the record shows on behalf of the borrowers and the legal heirs. The two,
Whether the borrowers have entrusted her to file the
Never.
application?
never, no Okalatnama was executed. Even the documents which has been shown as signed by the borrowers, that was never signed by them. Those signatures are not of them. That was a very specific case. Now, our claim, we filed a miscase, recalling of the order that was not entertained, that was dismissed.
What recalling?
Order passed by review, my lord. Review by the order passed by the DRT. That was, my lord,
Why review?
because, my lord, we indicated all these things. These are the misdeed, these are the mischief, or it's a fraud upon the court itself.
No, it's the surface proceeding.
Original application under section 19 of the RTP Act.
It's a recovery of debts.
Yes.
So, what was the final order passed?
Or
The
is it-
bank got a decree in its favor.
Decree passed.
Decree passed in favor
So,
of the.
decree is a nullity if it is against a dead person.
No.
No, they got the substitution. Substitution application was filed by Piyushana Chakraborty, my lord. In the first order recorded, he appears for the bank. And the next order it recorded, no, he appears for the defendant and legal heirs. He received herself the notice on behalf of the, my lord, substituted persons.
With the whether the decree or the order was passed, final order was passed after hearing the learned advocate for the
Yes.
borrower.
By Piyushana
Show me the order.
Chakraborty.
Yes.
By the Piyushana
Now,
Chakraborty.
Lordship, may I
Maybe
indicate
show me.
only one thing, Lordship?
You proceed against Piyushana.
Yes.
Proceed against Piyushana
But
Yes.
Chakraborty.
my claim before your lordship,
Only one thing I
she is a person.
This
If according to you,
No,
this
she
he or she was
entire
not
thing
authorized. you
no.
proceed
She is
against
a person.
thing has been
She-
decided by.
both of you will argue at the same time.
Lordship.
She is a person set up by the bank. She's a person set up by the bank. Otherwise, why she should appear, my lord?
She had executed the Vakalatnama, it is on record. Everything has been recorded in the review order.
Have you served the
No.
Piyushana Chakraborty?
No.
Serve her.
Now,
I will appeal on her behalf, my lord. My lord, the actual fact is that this petitioner has paid.
Serve
for a
her.
long time, my lord.
Serve her.
yes, my lord, I shall.
Ashwin.
I shall.
It has been alleged that one Piyushana, P-E-U-S-O-N-A Chakraborty, learned advocate, who represented the petitioner before the Debts Recovery Tribunal and filed several applications, was not authorized by the petitioner, she filed after the death of the original defendant.
Yes.
Was not authorized by the legal heirs of the original defendant in the proceeding before the Debts Recovery Tribunal
Even the signatures
To,
on those applications are not of us.
to কি বলে শুরু করলাম? Was not authorized by the petitioner / legal heirs of the original defendant before the Debts Recovery Tribunal to take steps on their behalf. First up, since an allegation has been leveled against a learned advocate, this court feels that the said learned advocate have to be put on notice. First up, petitioner is directed to serve a copy of this application upon the
Along with the report and exception, because all these are there.
what report?
They have filed the report, I have filed my exception, so everything is.
Serve a copy of the application along with other relevant materials which are part of the proceedings of this writ petition upon Piyushana Chakraborty, learned advocate. First up, she is available. She
My
is
lord, I
a
will be appealing on her behalf, my lord.
please furnish the particulars, address, and other thing where they will be served. You will not?
But I can also take the copy on her behalf of your lordship. And my lord, kindly she be added as a party, my lord, in this case.
Let them first serve, thereafter whether the, you know. At this stage, what is your name?
Rima Sarkar.
Ms. Nima Sarkar. Nima Sarkar, learned advocate, who usually appears before this court, submits that she has instructions to appear on behalf of Piyushana Chakraborty, learned advocate. In view of such submission, let copy of the writ petition along with other materials be served upon Ms. Sarkar, learned advocate, in course of
Tomorrow, my lord,
by tomorrow. বলে কালকে date. List this matter. Monday.
Monday.
Monday, my lord.
Monday.
Monday, my
or an interim order is there, my lord, let the be extended.
What is the
Lordship,
interim?
My lord,
the
6th
bank
of
is
March,
supporting
6th of March,
Interim order is subsisting.
6th of
No,
March,
it expired yesterday.
Yesterday,
6th March 2025, the order was passed. That
Expired
was
yesterday.
still because it was supposed to appear yesterday. Since it was not appeared yesterday, my lord, it is before lord.
Lordship, the bank has already pursuant to the order of the recovery officer DRT, the position is with the bank. Since the matter has been taken up.
written
from the
possession, nobody is disturbing you. What was the interim order passed?
Or
Not to take any
not to
coercive
take any
step.
coercive
We are not
steps.
taking any coercive step.
No,
Monday.
responsible authority shall not take any
Nobody
coercive
will not be affected by
measures.
the extension. The
6th of March 2025, that was the order.
the interim order,
Page
which
2,
was passed on March 11, 2025, is
Right.
extended till the end of. When is the next circuit? Starting
21st March.
21st of April,
April.
till the end of April 2025 or until further orders, whichever is earlier. I will list this matter on কবে বললাম? Monday.
Monday.
Monday under heading, my lord.
Affidavit in exception, you have filed
Exception.
today.
I have filed.
Affidavit in exception filed by the writ petitioner in court today is taken on record.
Grateful, my lord.
Yes,
it is-
your appearances
It is to be listed. It is to be listed under heading, my lord.
to be mentioned, on the same heading.
Great, my lord.
Yes, call the next matter.
I'm on behalf of the state, madam.
As I appear for the petition.
This is that matter.
129.
No physical copy was shown, madam. No physical copy was shown, madam.
No physical copy was shown. Madam, what is your instruction with regard to the invoice which has been annexed? We
Page
have
number
now
27.
page 27.
The invoice doesn't bear that, the
IRN.
yeah, QR code, my lord, which shows that, because they did not show this all invoice before.
That
the
is for
authority, my lord.
e-invoice.
That is
Nothing
for
is-
e-invoice.
Yes,
QR
madam.
code is for
Yes,
e-invoice.
my lord, these documents were not shown, my lord. And they have paid the amount, my lord.
They have paid, so there is no,
Intent
Uh,
to evade taxes.
no default in payment of tax.
My lord, they have paid the penalty and released the
No,
vehicle.
no, that is the penalty.
Yes, ma'am.
So it is not your case that there is any short payment, short
They-
deposit of
they-
duty.
They did not show any documents before the authority, my lord.
No,
So
but
until and
While,
unless they show
while
the-
imposing penalty, you have not said that the duty was not paid on the goods.
Yes.
Yes, that is true.
Then,
But this is an issue with regard to 129 when the vehicle is flying without any documents, my lord.
yes, yes, that I appreciate, but
That
it's
is
not
on
a case of,
38A.
it's not a case of non-payment of
No, no,
duty
this is
or,
not the case.
or short payment of
Yes,
duty.
yes, that is not the- They did not show any document before the authority. my lord.
That is the reason why they have come here.
Yes.
That is the only reason they have come here. Who are you? You are a dealer.
Yes, my lords.
Where have you stated? In which paragraph?
My lords, para number. I have not specified the specific business, my lords.
So you are a registered person under
Yes,
the,
I am on RT.
this.
Para 2.
This writ petition is at the instance of a registered person under the West Bengal Goods and Service Tax Act 2017 and is directed against the order of the additional commissioner, state tax, West Bengal, Siliguri Circle, Siliguri, dated January 16, 2025. Any appeal number is there?
Yes, my lords, page number 47.
Where is the number?
Appeal
My
by
lords-
ARN number,
Hey, yes.
is ARN number.
Second paragraph, my lords. ARN number.
In the matter of ground of appeal raised by the registered tax.
Only matter of ground of appeal.
Yes,
But
in the
page
memorandum of
47.
appeal, why
Page number 47.
47, second paragraph from the top,
And
Oh, yes.
ARN number.
The long being in appeal being number ARN capital in page 47 এ না আমি মার্ক করে দিয়েছি অনেক বড় নম্বর আছে প্যারাগ্রাফ paragraph na in appeal number thereby affirming the order, thereby affirming the penalty order dated May 22, 2024 passed by the proper officer and Deputy Commissioner of State Tax, Bureau of Investigation, North Bengal Headquarter, Shiliguri. In here there is a case number. No,
Yes, my lords.
where?
My lords, in the page number 47, there is that third paragraph, order reference number is there. In the matter of adjudicating officer, order reference number ZT.
That is the reference number.
Yes, my lords.
In order reference number, ওটা mark করে দিলাম, paragraph. The conveyance carrying the goods in question was intercepted by there are two matters is identical, dates are same,
Yes, the date of detention is the same.
date of interception
Interception, yes.
is
Just
the
the
same,
appeal orders are different dated.
orders date are different.
Appeal orders are differently dated, but the date of interception, detention by the adjudicating
Same
officer is
place.
Same.
Same place.
Same dealer also.
Intercepted by a team of officials on 17th of May 2024 at about 10 p.m. at Jalpaiguri. It is alleged that at the time of interception, the person in charge of the conveyance could not produce any tax invoice relating to the movement of goods.
As well as e-way bill.
No, e-way, that is not the.
E-way bill produced.
Yes,
That is not the ground of in the E-way bill.
should be tax
First up.
invoice is ground.
In view thereof, the goods were detained by issuing an order of detention. Paragraph. Thereafter, the authorities issued a show cause notice proposing the penalty payable by the petitioner. Full stop. In the said show cause notice, apart from the ground of non-production of tax invoice, it was stated that the vehicle was intercepted at a point which is not en route,
Yes.
which is not en route geographically as per the declaration made in the
Correct.
e-way bill. Full stop. The penalty paragraph, the penalty proposed in the show cause notice was, however, confirmed by the order, dated May 22, 2024, passed by the adjudicating authority as the penalty proposed in the show cause notice was duly paid. First up, accordingly, the authorities issued a release order and the goods were released thereafter. First up, being aggrieved by the order imposing penalty upon the petitioner, comma, an appeal under section 107 of the GST goods of the goods and of the West Bengal Goods and Service Tax Act 2017 was preferred. Full stop. Such appeal, such appeal, full stop. The appellate authority rejected the said appeal by the order dated January 16, 2025. Full stop. Being aggrieved by the order of the appellate authority, the petitioner has approached this court by filing this writ petition. First up, paragraph. The learned advocate appearing for the petitioner submits that the person in charge of a conveyance is not required to carry the physical copy of the tax invoice and the image of such invoice as available in the mobile of the person in charge of the conveyance amounts to sufficient compliance of the provisions under section 138 capital A of the West Bengal Goods and Service Tax Rules, 2017. First up, in support of such contention, he placed reliance upon a decision of a coordinate bench in placed reliance upon a decision of the coordinate bench in WPA 3415 of 2022 in the case of J.K. Jain Buildtech India Private Limited versus Assistant Commissioner ... order dated, the order dated April 3, 2023. The learned advocate for the petitioner further submits that mere deviation in the route with regard to movement of the goods cannot be the ground for imposition of penalty under section 129 of the 2017 Act. First up, in support of such contention, the said learned advocate placed reliance upon the decision of the Honorable High Court of Karnataka in the case of Joint Commissioner of Commercial Taxes within bracket appeals -3, Bengaluru versus Transways India Transport reported at 2024 164taxman.com 673 within bracket Karnataka. Full stop. For such proposition, the said learned advocate also placed reliance upon a decision of the, this is of which court?
Allahabad High,
Where do I find?
versus state of UP Millets.
Of the Honorable High Court at Allahabad in the case of Messrs. Vishal Steel Supplier versus State of UP and three others, reported at 2024 colon AHC colon 113213. Full stop. He further refers to a decision of the Honorable Division Bench of this court in FMA 136 of 2025 in the case of Ashok Sharma versus the state of West Bengal and others, order passed on February 11, 2025 in support of his contention that Section 129 of the 2017 Act could not have been invoked in case there is no intention to evade payment of tax. Paragraph. Par contra, the learned advocate appearing for the state submits that that section 138 capital A of the 2017 Act specifically provides that the physical copy of the tax invoice are to be carried by the person in charge of a conveyance and upon being required to produce the documents prescribed under the said rule, the person in charge of the conveyance shall be liable to produce the documents and allow inspection of the goods. She submits that since the provisions of the relevant statute and the rules framed thereunder was not complied with, the authorities were justified in detaining the goods and thereafter releasing the same upon payment of penalty. Yes, nothing more.
There is another judgment of Asian which clearly says mens rea is not important in case of 138A.
First up, paragraph, heard the learned advocates for the parties and peruse the materials list. First up, paragraph. Section 68 of the 2017 Act deals with inspection of goods in movement. Subsection 3 of section 68 states that empowers the intercepting officials to require the person in charge of the conveyance to produce the documents prescribed and upon being required to do so, the said person shall be liable to produce the documents and devices and also allow the inspection of the goods. Paragraph. Rule 138. For the purpose of better appreciation of the contentions of the respective parties, it would be beneficial to recapitulate the provisions laid down in Rule 138 capital A of the 2017 rules, and for such purpose, the said rule is extracted hereinafter. The relevant portion of the said rules is extracted hereinafter. Bole na 138 capital A 1 A B আর 2 এই দুটো এক্সট্রাক্ট করব, ঠিক আছে, করে ওই 3-4টা যেরকম ক্রস দিয়ে ইনভার্টেড কমা দিয়ে দেয় সেরকম ভাবে করবে, 1 আর 2টা করবে। Subrule 1 of Rule 138, না, Subrule 1 না, Clause A, small a of Subrule 1 of Rule 138 capital A of the 2017 rules states that the person in charge of a conveyance shall carry the invoice or bill of supply or delivery challan, comma, as the case may be. Full stop. Clause B of Subrule 1 of Rule 138 capital A speaks of a copy of the e-way bill, e-way bill. First stop. Subrule 2 of Rule 138A deals with invoices issued in the manner prescribed under Subrule 4 of Rule 48. First up, it speaks of invoice to be produced electronically for verification by the proper officer in lieu of physical copy of such tax invoice. The paragraph. Upon a conjoint reading of Subrule 1 within bracket A and Rule 2 and Subrule 2 of Rule 138 capital A of the 2017 Act, of the 2017 rules, this court holds that the person in charge of a conveyance has to carry the shall carry the physical copy of the tax invoice except in cases falling under Subrule 2 of Rule 138 capital A of the 2017 rules. Thus, for such reason, this court is not inclined. Again. It is not the case of the petitioner that the tax invoice was produced electronically. Therefore, the petitioner, therefore, the person in charge of the conveyance was under a statutory obligation to carry the physical copy of the tax invoice. Full stop. For such reason, this court is not inclined to accept the contention of the learned advocate for the petitioner that displaying the image of the tax invoice from the mobile set of the person in charge of the conveyance amounts to sufficient compliance of the requirements under Rule 138 capital A within bracket 1 of the 2017 rules. Full stop. Paragraph. Now, this court has to consider the other ground raised in the show cause notice for imposition of penalty. Paragraph. It has been alleged in the show cause notice that the person was, that the conveyance was intercepted at a point which is not en route, en route geographically as per the declaration made in the E-way bill of the made in the E-way bill. Full stop. The learned advocate appearing for the state in course of her argument could not point out any provision either from the 27 Act or from the rules framed thereunder that the that there is a specific provision which there is a specific provision which casts an obligation upon the registered person to which casts the selling dealer to disclose the route to be taken during transportation of goods. Paragraph. In Messrs. Vishal Steel Supply Supra, the Honorable High Court at Allahabad took note of the fact that there was a provision under the VAT Act, VAT Act, all capitals, to disclose the route during transportation of goods to reach its final destination. It was further observed that once the legislature in its wisdom has chosen to delete the said provision, now, কি বললাম? No, it was further. The Honorable Court opined, that তারপরে কি বলেছিল? It was further observed জায়গা শুধু হবে that once the legislature in its wisdom has chosen to delete the said provision, the authorities were not correct in passing the seizure order, even if the vehicle was not on regular route or on different route. Full stop. In Transways India Transport Supra, it was held that merely because of the fact that the direction preferred by the petitioners therein, direction preferred for delivery of consignment to the place destined for, an inference cannot be drawn to the place destined for, destination থেকে destined for, an inference cannot be drawn with regard to the intention to evade tax. First up. Thus, thus it is well settled that mere change of route, or even if the conveyance is intercepted at a location which may not be en route geographically as per the declaration made in the UA bill, cannot be a ground for invocation of the provisions of section 129 of the 2017 Act. Full stop. It is not the case of the revenue that there is any discrepancy as to the quantity. It is not in dispute that the e-way bill was produced at the time of inspection of the goods carried by the conveyance. Full stop. It is not the case of the revenue that there is any discrepancy as to the quality or quantity of the goods as mentioned in the e-way bill with that seen at the time of physical inspection of the goods which were in the conveyance. Full stop. Paragraph. The appellate authority in its order dated 16th of January 2025 has not arrived at a specific finding that has not returned any finding that there was any intention on the part of the petitioner to evade payment of tax. Full stop. The petitioner though the petitioner may not have produced the tax invoice either before the adjudicating authority or before the appellate authority, but the fact remains that a copy of such tax invoice has been annexed to this writ petition. To stop. It is also not the case of the revenue that there has been any default in payment of tax, duty, or default or short payment. Default or short payment of any tax or duty. To stop. The veracity of the tax invoice, which is annexed to this writ petition, has also not been questioned by the revenue in course of hearing of this writ petition. Full stop. Paragraph. So the fact remains that the petitioner failed to produce the tax invoice, the physical copy of the tax invoice, either at the time of detention or at subsequent stages till the appellate stage, but since this copy of the tax invoice has been disclosed in this writ petition, this court is of the considered view that the order of the appellate authority affirming the penalty order passed by the original authority, by adjudicating authority, calls for interference. First up. Paragraph. The আচ্ছা এইটা যেটা বললাম না তার আগে না একটা প্যারাগ্রাফ একটু অ্যাড করুন, তো প্যারাগ্রাফ হবে, এটা রাইডার এ করুন। The Honorable Division Bench in Ashok Sharma Supra held that in case there is no dispute as to the quantity or weight of the weight of the goods, and also that there is no intention to evade payment of tax, the provision under section 129 of the 2017 Act could not have been invoked. ঠিক আছে, এটা হচ্ছে রাইডারে। আর যেখানে আমি বলেছি না দিস কোর্ট ইজ ওই ফিজিক্যাল কপিটা 138 এতে এ করতে হবে, সেখানে একটা প্যারাগ্রাফ লিখে দেবেন যে this view, now the view of this court is also supported by the view of the coordinate bench in JK Jain Buildtech India Private Limited Supra, wherein it has now wherein full stop paragraph. For all the reasons as aforesaid, the order passed by the appellate authority dated January 16, 2025, affirming the penalty order passed by the original authority dated May 22, 2024, are set aside. Full stop. The writ petition stands allowed. Full stop. Now you want refund. Petitioner will be at liberty to seek refund of the penalty already. Now the petitioner will be at liberty to approach the concerned authority for refund of the penalty already paid by the petitioner. Full stop. If such an approach is made, such authority shall refund the amount as expeditiously as possible. But positively, madam, 3 weeks, within a period of 3 weeks from receipt of a server copy of this order, along with the copy of the application directed to be submitted in terms of this order.
I'm grateful, my lords.
Thank you.
My lords, next item, some dates has to be changed.
Please give the change of dates only. ওই পরের আইটেমটাও সেম অর্ডার। নেক্সট।
Grateful.
I'm grateful.
Yes, my lord, this is my question.
Yes.
My lord, in this application, what really happened is in 2022, my daughter's marriage was there. And for my daughter's marriage,
Yes, Mr. Basu.
yes. And for my daughter's marriage, my lord, I gave a contract to a certain person. He executed the contract also. And in that contract, the total value was around 3 lakhs. He took 1,50,000 rupees from me in 2 installments. And then just 2 days prior to the occasion, he said, I cannot do it. My lord, I had to get the money from somewhere else, and then I did my daughter's marriage. Thereafter, the police took up the FIR started investigation and kindly sees, without even apprehending this person or calling him to the police station, file a charge sheet and take a lordship to the charge sheet itself.
Mr.
The
Basu,
mayor
it's
take a lot-
purely, Mr. Basu, is it not purely a private, civil dispute? It's a breach
Civil.
of a contract. Mr. Basu, it's a breach of a contract violation. So remedies are available. So
My lord, this is
merely by saying,
my lord, there is an element of cheating, law. There is a charge sheet. But
yes,
the point
cheating,
is,
you have only tried to make out a case of cheating for that, but it's purely a contractual dispute. If there's a breach of a contract, remedies are available, Mr. Basu.
very true.
And
My lord, he has cheated us.
very recently, the Honorable Supreme Court has laid down that in this case of contractual disputes, don't entertain these FIRs and other things. It's purely
My
a
lord, this is not for-
contractual dispute, Mr. Basu. All these you are bringing into the criminal
But
jurisdiction.
once the FIR has been given, he has not been apprehended. Lordship, he's not been apprehended. The bank account has not been seized, and he's roaming free from 2022.
What will be seized,
Can
Mr.
be seized.
Basu? What will be seized?
The bank account has to be freezed, mother, freezed. He has
Uh,
not even frozen that.
Why?
He has given a notice under
Basu.
41A.
Mr. Basu, if you can prove this contract is to be proved, whether there is a valid contract in the eye of law, that is to be proved, whether you have paid this amount, that has to be proved, whether
He
you are
has taken- he
entitled
has
to
taken all
refund of
documents.
that, what is the
Yes.
and damages, that cannot be ascertained by the criminal court. If
My
there
lord,
is a breach of
all the
contract,
documents,
there may
all the
be two
documents,
things. You may have
he has taken.
refund of the amount, or you can claim damages also because you have suffered something because he failed to perform his part of the contract. You are also entitled
That is-
to damages.
That is one of the element of cheating. 418, 19 and 20 says that if you have known that you are not going to perform a duty and take some money from somebody, and then you do not refund it or do not perform, that's the element of cheating, madam. If that's the element of cheating, this falls squarely within it.
So
From day one,
FIR
he
has
knew that
been
he is not going to
registered.
perform.
Mr. Basu, FIR has been registered. So
Charge sheet has been given.
I-
Charge sheet has been given also.
charge sheet
charge
has
sheet has
been
been
given.
Yes, yes. And only thing is, madam, he has not been apprehended, and no investigation has been done against him.
You can
And only on that.
approach the concerned jurisdictional magistrate with regard to that. Charge sheet has been filed, can approach the concerned court. If you are aggrieved
Well-
by the charge sheet, you can approach that forum.
I
Well,
can,
what will it be
definitely, madam. At the same time, your lordship will kindly direct that the entire thing is expedited, madam. The entire trial is expedited. Because if he is not apprehended, the trial cannot commence. If the person accused is not apprehended, the trial cannot commence. So, madam, that is what is being done. Madam, he is absconding. Kindly directs that the entire trial to be commenced immediately and
Yes,
proceeded
I
and
can,
finished.
I can direct that the trial to be completed as expeditiously as possible.
Lordship,
Yes,
in this
within a
matter, I
specified
led by
time.
learned additional advocate general.
Specified time, Mr. Basu, it's very difficult. You are aware of the recent Supreme Court decisions.
But where do they go in a
Directions for
criminal trial?
expeditious,
Madam?
don't fix a time frame. Those are the decisions.
I know. But at the same time,
Then-
madam, I will be praying, madam. I will be praying, madam. We
So I can-
pray,
I
madam.
can-
There were directives.
Yes, I can only say yes. Yes, madam.
Lordship, I led by
No-
learned additional
nothing,
advocate
madam.
general, who is
Your lordship
appear
has
virtually,
already,
lordship.
Is
already has
visible
so much-
virtually.
Lordship already everything, all the.
Nothing remains. Nothing remains, my lord. What your lordship has fallen from your mouth.
And one more thing, madam, the police will apprehend this person, madam. Otherwise, the trial will not commence.
Yes, I am directing.
Only that
Yes.
much.
Do you have a copy of the report?
Lordship, yes, Lordship, police already pray for issuance of WA, Lordship, and next date was fixed for 2/6/2025 for SR. Summon was issued by the Blanded Chief Judicial Magistrate, Kalimpong.
Someone will not do, madam, for 3 years. He is
This is a
roaming around.
discussion of the court, Lordship. This is not.
So
And
you
the
can
account
approach
has
the
not been
concerned,
frozen.
Mr. Basu, it's pending before the Chief Judicial Magistrate. I will give you liberty to approach the Chief Judicial Magistrate for necessary orders, and I will also direct expeditious disposal of this trial.
And the police
Absolutely.
will take necessary steps, madam. Police will take necessary steps.
The grievance of the petitioner is that the police authorities have not taken any step, have not taken any effective steps,
Yes.
accepting registration of an FIR pursuant to the complaint lodged by the petitioner. First up,
And also a charge sheet. They have also given a charge sheet.
yes,
They
that,
have given a charge sheet.
so I have recorded that accepting registration, they have not done. I will record now the charge sheet has been filed.
Yes, that's it.
The petitioners claims that there was a contract between the petitioner and the private respondent who is running a catering business for performing the
Marriage ceremony.
for making catering arrangements
Yes.
on the account of the marriage ceremony of the daughter
Daughter.
of the petitioner. It has been alleged that though an earnest money pursuant to such contract
1,50,000.
earnest money pursuant to such contract was paid, but the private respondent failed to perform the his part of the contract. First up, paragraph, Mr. Basu Lanet, senior advocate appearing for the petitioner, submits that since the private respondent did not perform his part of the contract, the petitioner had suffered serious loss and prejudice,
Constraint. Grateful.
as well as financial constraints. He submits that since there was a motive of
Eating.
of cheating, the petitioner lodged a complaint with the police authorities, and only an FIR has been registered, but no steps thereafter. But no,
No, the charge sheet has been. The charge sheet has been given, submitted.
But no effective steps accepting filing of a charge sheet has been taken.
Lordship,
Malad, the
also
charge sheet
paid-
is an effective step. What more steps can be taken?
Lordship, police also
That is-
paid a pair of issuance.
Should be apprehended. He has not been apprehended.
That
He
is
has
his
not been
submission.
apprehended.
আচ্ছা নো আচ্ছা এটা ঘুরিয়ে লিখুন তো এটা কি বললাম
He has not been apprehended, my lord.
the petitioner and only an FIR has been registered and a charge sheet has been filed without taking any effective steps for apprehending the accused. Paragraph.
Yes.
The learned additional advocate general appears through the virtual mode. He submits that immediately after receiving the complaint, an FIR was registered, and after completion of investigation, the charge sheet has been laid. He further submits that the Chief Judicial Magistrate has issued summons to the accused, and a date was fixed and the next date has been fixed on 2nd of June 2025 for service returns. First up, since the matter is pending before the learned Chief Judicial Magistrate Kalimpong, petitioner will be at liberty to approach the Chief Judicial Magistrate for any reliefs. First up, the learned Chief Judicial Magistrate Kalimpong is requested to conclude the trial expeditiously. With the
Grateful,
above
my lord.
observations and directions,
And the police will take necessary steps, my lord.
What
that will be
steps?
done.
Necessary.
Summons has been issued. কি বললাম? With the above observations and directions, WPA number such and such stands disposed of.
Grateful,
Grateful, my lord.
Grateful, Lord.
grateful, much obliged, my lord.
My lord, after I part, my lord, I'll make a submission, my lord. This
After,
is before I part, my lord.
yes,
This is a case of two learned advocates practicing in the High Court. They were getting married.
oh,
Grateful, my lord. Grateful.
thank you, thank you.
Grateful, Lord.
Yes,
I,
My lord, serial number 5, my lord, I'm for the petitioner, my lord. Serial number 5.
yes, yes.
I'm for the statement.
My lord, I'm for the petitioner. My lord, petitioner has plying his 2 vehicles, my lord, STP permit. The route at Kuch Bihar, my lord. My lord,
Yes.
after that, my lord, he received 2 transportation offer letter from St. Xavier School at Kuch Bihar. On
Yes.
that basis, my lord, he surrendered 2 PSTP vehicle before respondent authority. And after that, for my lord, transfer his PSTP permit to only his prior. He plying his 2 bus on the Kujbihar road as PSTP permit.
Yes,
And after
yes,
that,
Mr.
my
Pal.
lord, he
If you should kindly comes to,
Have you taken any decision?
yes, yes.
Where is the
my lord,
decision?
rejected my prior, my lord.
Where
My
is
lord,
Page 18, my lord.
1-8?
Page 18, my lord. Rejected my prior, my lord, only the ground.
Permissible, my lord.
It's not
There
permissible.
is no provision to transfer.
My lord, in
You have not
another,
assigned any
my
reasons.
lord,
Mr. Paul, you have not assigned any
Whether,
reasons.
could not be considered for issuance of permit as the vehicle in question are covered by permanent stage carriage permit.
Not
already
reasons.
there is a
Show me
state
the provision. Where is the violation? Which provision of the statute?
Let them show that how it can be transferred from one stage carriage permit to us.
Mr. Paul, you are saying it's not permissible. You are the authority.
Well, they are seeking transfer. Whether it is
Yes.
permissible or not, they
You have to quote that there is no provision.
Well, then I'll seek report.
What
my
report?
lord, one thing, my lord. My lord,
Yes,
in
under what
another
provision
number
this?
of buses, my lord,
Yes, under
my
what
lord, another
provision
number of buses,
this conversion is permissible? Show me the provision of the statute which permits
my lord,
this change.
my lord, if not permissible, my lord, how the respondent already allow to another vehicle to for transfer PSTP to school, my lord.
Where is that?
Number of I have mentioned in my application. Those
Mr.
buses,
No document has been provided. How we can verify that?
number of buses, my lord, he
Yes,
transferred the
give him the
PSTP
numbers.
to
Page
I have
4,
mentioned
paragraph
in my
7.
caption, my lord. Also, my mention in my prayer, my lord.
Page 4, paragraph 7.
My lord, I have mentioned.
Monday I shall come with the report.
The petitioner alleges that those similarly situated persons were allowed to were allowed conversion from permanent stage carriage permit to permit for running school bus. The authorities have discriminated against the petitioner by rejecting the prayer of the petitioner for issuance of permit, for issuance of school bus permit. First up, paragraph, it appears from the writ petition that the petitioner has specifically mentioned the registration numbers of the vehicles in respect of which the PSTP permit has been transferred to, has been converted to school bus permit. Mr. Pal, honored advocate appearing for the state, seeks time to file a report with regard to such allegations. List this matter on Tuesday when the, who shall file a report when the,
Secretary Regional
My lord,
Transport.
RTA
When
Kuch
the,
Bihar, respond, my lord.
when the region, when the Secretary, Regional Transport Authority, Kuch Bihar, being the second respondent, shall file a report in the form of an affidavit in this regard.
My lord, one thing, my lord, for
this matter
liberty
on
to
Tuesday.
correct, my lord,
If you
on
satisfied-
my
Yes.
prayer, praying for liberty to correct paragraph number 7 and prayer portion, Samkel number is mistakenly my wrong number, my lord.
That you cannot correct the body of the application. You cannot do so because it has to be reaffirmed. You can file a supplementary affidavit. Please
But
furnish
my
the
lord,
correct
my lord,
numbers to Mr. Pal so that he can take instructions on that.
Yes, my lord, I am praying for liberty
as-
to file
As
supplementary
paid for by
affidavit.
the learned advocate for the petition একদম উপরে দেবেন. Leave is granted to the petitioner to file a supplementary affidavit. Full stop. Full stop.
My lord, that will help,
Please
my lord,
supply the
when my
correct
lord,
numbers to Mr. Pal in course of this day.
that will appear on which date, my lord? My lord, next date is, my lord.
Tuesday.
After 8, my lord, if your lordship kindly fix after 8.
After
After
8,
8 of this month. 8, my
then
lord.
it will be next
Yes, after
circuit.
8 April.
Then it will be next
My
circuit.
lord. My lord, next circuit, my lord. Not available, my lord.
List this matter before the next available circuit.
Of lord.
Tuesday জায়গা list this matter before the next.
They will be using a supplementary affidavit. Let that copy be supplied for us. Based on the document that was seen.
তাহলে ওটা এই করে দিন, তাহলে এক্ষুনি রিপোর্ট করার দরকার নেই। ওই যেটা আগে বলেছি না, let such supplementary affidavit be, let a copy of such supplementary affidavit be served upon Mr. Pal, learned advocate for the petitioner. On or before April 10, 2025. ঠিক আছে, তারপরে ওই রিপোর্ট ইন দি ফর্ম অফ এফিডেভিট অন অর বিফোর দি সেটা থাকবে। হ্যাঁ হ্যাঁ না ওটা হচ্ছে সাপ্লিমেন্টারি এফিডেভিটটা টু বি ফাইলড অন অর বিফোর। হ্যাঁ অন অর বিফোর এত হলো। আর যেটা বলেছে না যে ওই স্টেট শাল ফাইল এ রিপোর্ট ইন দি ফর্ম অফ এফিডেভিট, সেইখানটা করে দেবেন অন অর বিফোর দি নেক্সট ডেট অফ হিয়ারিং। This matter before the next available circuit.
Affidavit in service.
List this matter before the next available circuit date. আর যেটা হচ্ছে on or before the next date of hearing করে দেবেন। Upon serving, ওটা করে দিন on or before the next date of hearing, upon serving an advance copy of such report to the learned advocate for the petitioner. Please serve them. Yes, next.
Lordship,
Here is
affidavit
my
in
lord,
service. I
affidavit
have
service.
filed.
Yes,
For the petitioner.
petitioner, yes.
So the petitioner has filed the writ petition praying for a transfer of from one school to another school. That is a different circle from one circle to different circle. The prayer for transfer was filed in the year 2022 through online. Subsequently, it was filed manually before the concerned the district primary school council. So what happened during the pendency of the writ petition, the respondent number 6 had called upon a hearing, and thereafter he considered my prayer. And thereafter he an alternative accommodation for giving a transfer school has been proposed, and an application has been sought for from that particular hearing from the petitioner, wherein the petitioner has made a application, one-page application, praying that he intends to go to at one Saraswati Hindi primary school, Kalchini Circle, which is a teacher deficit school. So in the meanwhile, this development has been cropped up. So may I propose, Lordship, in the since this development has been cropped up, what subsequent steps they have taken to give effect of this transfer, Lordship, from the DPSC?
Yes, what is your instruction?
Service has been made, Lordship.
Where is their letter?
My first prayer, Lordship.
No. This was pursuant to where is the notice of hearing?
Notice of hearing during the pendency of the writ petition.
During the
Post-filing.
pendency of the writ
Yes,
petition.
that's what I couldn't.
What was your last prayer pursuant to which this notice of hearing was given?
No, initially there was no hearing was called on.
No.
That's what-
Pursuant to which representation hearing? Where is the hearing notice? Show me the hearing notice.
No hearing was called for. Only-
Yes, you have said that you have attended the hearing.
Yes, this is after filing of this writ petition.
Yes, where is the notice of hearing?
The notice of hearing is not readily available, Lordship.
Who is appearing for the district primary school council? Have you served them?
Yes. This is evidence service.
Ashun. Evidence service filed. You are appearing. So Dhar, you are appearing.
Alipurduar.
Mr. Ghosh, where is he? Ask him to come.
Is not present today.
You are his junior. So in one matter, he has applied for transfer. He has said that the DPSC Alipurduar has called him for a hearing. He attended the hearing and he has given to the name of one school. So I'm directing you to take to consider that and to take a decision. with
Lordship,
regard.
what they have stepped, let them come with the step that have been that they
I will direct him to take a decision that will be communicated. The petitioner, where are you now posted?
now posted at Karadanga East Line Primary School.
Which paragraph?
4. Paragraph 4, page 4.
The petitioner is an assistant teacher at Garganda East Line Primary School under Madarihat Circle in the district of Alipurduar. The petitioner states that it is difficult for the petitioner to attend the school from his or her
Is
from his residence, and for such reason he applied for transfer to a nearby school. Paragraph. When this matter is taken up for hearing, the learned advocate appearing for the petitioner submits that the petitioner submits that pursuant to the prayer for transfer made by the petitioner, he was called for a hearing by the authorities of the District Primary School Council, Alipurduar. He further submits that the petitioner duly attended the said hearing and before such authority,
this one number
yes,
5. This one number 5.
he has stated that Saraswati Hindi Primary School within Kalchini Circle is a teacher deficit school which is near to the residence of the petitioner. First up, the petitioner requested the said authority by a letter dated March 20, 2025 to transfer the petitioner to Saraswati Hindi Primary School under Kalchini Circle. First up, the learned advocate appearing for the petitioner submits that no decision on such prayer of the petitioner has yet been communicated to the petitioner. First up, the state is represented by its learned advocate. Affidavit of service filed in court today is taken on record. First up, none appears for the District Primary School Council, Alipurduar. First up, Mr. Ghosh, learned advocate, who usually represents the District Primary School Council, Alipurduar, is requested to appear in this matter. First up, let a copy of the writ petition be served upon Mr. Ghosh in course of this day. First up, since the petitioner attended the hearing before the authority of attended the hearing
Before the response number 5.
before the
Response number 5.
attended the hearing conducted by the chairman cum secretary, District Primary School Council, Alipurduar, being the fifth respondent hearing, such respondent authority is directed to take a decision on the prayer of the petitioner for transfer and to communicate such decision to the petitioner as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order, along with the copy of the representations praying for transfer, as well as the letter dated March 20, 2025, which has been produced in course of hearing of this writ petition. With the above observations and directions, WPA number such and such stands disposed of. ওই যেখানে বলেছে না ও submits that তো ওইখানে একটা লিখে দেবেন the copy of the letter dated March 20, 2025, which has been produced by the learned advocate for the petitioner in court today, is taken on record.
Grateful.
When he will be giving the copy of the writ petition, please give copy of this letter also. Please.
Yes.
Yes, next. If your service now taken on record.
My lord, service is not ready. Kindly take it on Monday.
What is this matter?
Delayed payment on pension.
Since the service is not complete, list this matter on when?
Monday, any day.
On Wednesday. Petitioner is directed to serve a copy of this application upon the respondents and file an affidavit of service on the next date. Yes, call the next matter.
Lordship, in this matter.
Yes.
Matter, I'm praying for time, Lordship.
Why?
One day of completion. Mr. Ghosh is not present today. He has fallen ill.
Yes, fallen.
Ill.
He has not come to court.
Lordship.
আচ্ছা তাহলে না আগেরটাতে you are also in the panel of advocates of Alipurduar.
I'm not.
Mr. Ghosh already. Thank you. Yes, call the next matter. What do you want? Not today
Not today, Lord.
or not this week?
Lordship may keep it on Monday.
Not this week করে দিন। Yes, next. Order record করে দিন। On the prayer of the learned advocate for the petitioner, hearing of the matter stands adjourned for this week. Next.
Lordship, in this matter, returnable date is 4/4/2025.
4th of,
March, April, Lordship.
no.
Yes, Lordship, in our copy, returnable date.
In my copy, it's 3rd of April. All right. It has been none appears for the petitioner at the time of call. No accommodation has been sought for either. First of the learned advocate appealing for the state submit that in the communication letter, it has been mentioned that this matter will appear on 4th of April 2025. This matter on 4th of April.
Grateful, Lordship.
ওনাদেরকে সার্ভ করেছি কালকে করে দেব। নেক্সট yes
I'm for the respondent municipality, madam.
respondent municipality. What is this matter?
Madam, they are praying that the earlier order has not been complied with and they are praying for compliance of the order via the statement.
Terminal benefit of retirement.
Yes, madam.
Yes, why have you not paid the retirement benefits?
Well, there was direction to conclude a hearing and take a decision on the figure. The hearing was held yesterday. The decision was also passed. Probably today they also served also the decision of the hearing.
What is the decision of the
I
hearing?
do not have it on me right
You
now.
do not have. You know
Tomorrow-
everything.
No, well, right now my client has contacted me, so I know that the hearing. Let it go on tomorrow or day after tomorrow, I'll come back with whatever.
Ashun, none appears for the petitioner at the time of call. No accommodation has been sought for either. First of the learned advocate appearing for you are for the municipality.
Thank you very much.
The learned advocate for the municipality submits that pursuant to the directions passed in
Page number 15, my lord.
15,
Page number 15, WPH 656 of 2024.
pursuant to a direction passed in WPA 2656 of 2024 on 7th of January 2025, a hearing was conducted yesterday, that is Calcutta date the 11th, and the decision of such hearing shall be communicated to the petitioner in course of this day.
Petition was present in the hearing.
It has been submitted by the learned advocate for the municipality that the petitioner attended the said hearing. First up, list this matter tomorrow.
Huh? Get over.
But as paid for by the learned advocate for the municipality, list this matter tomorrow. Yes, next.
Kindly keep the matter on next. Mr. Ghosh is not present.
Mr. Ghosh is not there. Where is the learned advocate on record?
He is also not there.
She is here. Learned advocate on record is here. Where is she?
GST matter.
Not this week.
Break.
On the prayer of the learned advocate for the petitioner, list, hearing of the matter stands adjourned for this week. Yes, next.
That item 12 by IPR for the petitioner. That am I audible?
In which matter?
Item 12.
Let it be called on. Yes.
My lord.
Yes.
Well, affidavit of service is ready. Everybody has been served. Now, let this matter pertains to disbursement of additional increments. 2 additional increments of the petitioner who is presently employed as assistant professor of Bengali at a college of Jalpaiguri.
Yes, who is appealing for the state? Respondent number 4.
Not the answering respondent, my lord, only my name will be incorporated.
Only your name has been incorporated. You must thank the petitioner for that. Yes, yes, Mr. Pal, you are appearing. Instruction?
From the respondent number 2.
You have not got instruction. Yes, what is your prayer? What do you want?
A disbursement of 2 additional increments, which the petitioner is entitled to upon completion of her PhD degree. MPhil degree, sorry, my lord, MPhil degree. Now, my lord, I am relying upon the notification at page 76, annexed at page 76.
Have they rejected your claim?
My lord, they have not considered even.
So I can direct them to take a decision on your, where is your representation?
My lord, my representation is, my lord, at page, my lord, 60, 61, 62, 63. 62,
63. Yes, please take a decision on this. Yes, Mr. Pal, take a decision on page 62.
Can you take it on Tuesday, my lord, so that I can?
You take a decision. He has made a representation. You
We
have,
have taken a, not a.
if decision is taken, communicate to them. Where are those notifications?
My lord, my notification is at page 76. Clause 2. Teachers who have entered into service on and after 1st of September 2008 with PhD, MPhil and other higher qualifications in his/her relevant subject, and the teachers who have acquired PhD, MPhil degree and other higher qualifications while in service on or after 1st of September 2008 shall be awarded advance increments in their initial scale of pay at the entry or lower scale of pay on the day of award of PhD/MPhil and other higher qualifications in the following manner. That has not been considered. I am addressing.
So the DPI is to take a decision.
Yes, my lord.
Yes, Ashun. The petitioner is an assistant professor in Bengali of Ananda Chandra Training College, Jalpaiguri. The petitioner claims to have completed his or her MPhil, P capital MPhil degree in Bengali. First up, the petitioner states that since she has completed the MPhil degree, she is entitled to 2 additional increments in terms of the government order dated November 4, 2016. The government orders dated November 4, 2016 and November 8, 2016. The petitioner alleges that that in spite of several representations being made, the respondent authority has not communicated its decision with regard to the prayer of the petitioner for release of 2 additional increments. Paragraph. The learned advocate appearing for the petitioner submits that the petitioner submitted her representation dated March 17, 2025, but the respondent authorities are sitting tight over such representation. First up, paragraph. Since the petitioner has placed reliance upon the government orders in support of her claim for additional increments on account of obtaining the MPhil decree. This court is of the considered view that the concerned authority has to communicate its decision, has to take a decision with regard to the prayer of the petitioner expeditious. Paragraph. Without entering into the claim of the petitioner, WPA 678 of 2025 is disposed of by directing the Director of Public Instruction, being the number 2, Director of Public Instruction, Department of Higher Education, Government of West Bengal, being the respondent number 2 herein, to consider the representation of the petitioner for dispersal of additional increments and to dispose of the same by passing a reasoned order after giving an opportunity of hearing to the petitioner or her authorized representative. It's needless to mention that such reasoned order has to be communicated to the petitioner immediately thereafter. The entire exercise shall be completed as expeditiously as possible, but positively within a period of 4 weeks from the receipt of a server copy of this order, along with a copy of the representation dated 17th of March 2025.
Well, the appearance of the university may be marked, my lord. I'm appearing for respondent number 4.
Yes,
Grateful, my lord.
University, and you are.
He is my colleague.
Please give your appearances.
Grateful, my lord. I'm grateful.
University is represented. Service file.
Grateful. Grateful.
Yes, call the next matter.
Grateful, my lord. My lord, affidavit of service I have already filed.
Yes, yes. Call the next matter.
I'm applying for state in respect of regarding the insufficient payment of on the interest on gratuity by this one. Upon the petitioner will be pension holder of the remand father who has been died on.
Interest, yes. What is your instruction?
They have made a representation, let that be considered.
Where is that?
Say advocate's letter 25.
Consider that can be done.
The matter is clear, the second payment has been not made as far as the calculation of the first payment.
Yes, who will consider this?
Treasury. The Treasury officer, they have not made a party.
Treasury officer has made a representation. DI is to take a decision. The petitioner claims interest on account of delayed payment of gratuity and arrear pension. The petitioner claims to have made a representation before various authorities, including the District Inspector of Schools, Secondary Education, Jalpaiguri, by letter dated January 27, 2025. First up, what is your claim? There's a wrong calculation of interest, or in the said representation, it has been stated that there has been a wrong calculation of interest. First up, this court cannot enter into a dispute with regard to calculation of interest. First up, and the same is best left open for the authorities to decide. First up, in view thereof, WPA number such and such is disposed of by directing the District Inspector of Schools within bracket KC Jalpaiguri, being the fourth respondent, to consider the representation of the petitioner dated 27th of January 2025 and to dispose of the same by passing a reasoned order after giving an opportunity of hearing to the petitioner or his authorized representative. First up, it will be open to the petitioner to place reliance upon any government order or any court orders in support of his contention as to the rate of interest that the petitioner may be entitled.
On respect of the payment which was made on 29th of July 2022, that on the particular date the payment was made, which is stated in Corona and stated in Annex page number 23. It has been only the amount has been written.
Yes, I've seen that. You raise all points. I've given you a little bit to raise all points. The petitioner will be at the time of hearing, the petitioner will be entitled to raise all points and to rely upon any government orders or court orders. Yes, next.
I'm appearing for the petitioner, Lordship.
Yes.
Lord, this matter, I should be very candid. What has happened, 2 pages of annexure, my lord, is missing. But I have given the annexure, handed over the annexure to my juniors. If Lordship kindly takes it up, the matter can be disposed of. Lordship will kindly see.
The impugned order is for the response number 6. The impugned order perhaps missing.
Yes. It's not the, yes. What has happened, my lord, here your Lordship had directed in an earlier application. Am I audible, Lordship?
Yes.
I'm grateful. My lord, in an earlier writ petition, your Lordship had, this is a dispute that I have wrongly filed my GSTR 1. Page 30 will speak for 36. Will speak for itself, my lord. This is your Lordship's order. Here,
Yes.
the problem was I had wrongly shown a B2B, that is business to business sale, as a business to consumer sale.
Yes.
That is the only wrong thing that I have done. And then your Lordship had directed the respondent authorities to take a reasoned decision that whether if I apply, they will open it, or whether not, a reasoned decision has to be taken. Now that reasoned decision has come, and they are only on the point that since section 37(3), there is a limitation for rectifying GSTR 1, that limitation period is over. So you are not entitled to do that.
Where is the reasoned order?
My lord, I'll ask my learned junior to hand over the annexure.
Oh, that has not, you have not annexed that.
That is what has happened, my lord.
Yes, madam, have you got that?
Yes, I have given it to them.
So are you ready, or you want to go through that?
My lord, it is just only thing is that they have written that this one cannot be done on the pretext that it's marred by 37(3).
Where is that?
Lordship will take the second page. They have cited section 37, and thereafter the whole section 37 is cited.
Yes.
And then thus in consideration of inadvertent mistake in filing GSTR 1, the statutes incorporated the provisions for rectification. In the instant case, time limit for rectification was given as per 37. Thereafter, the next page, the last page rather, the RTP was aware of the mistake, but did not rectify the mistake within the stipulated time. The prayer submitted to respondent number 1 was on so and so, that is long after the due date. And therefore, my lord, they have.
Yes.
Now, on this, the division bench of Calcutta High Court, the division bench of Bombay High Court, and also the Honorable Supreme Court have now come up with decisions that exactly on the same pattern, the point. First, my lord, the decision of the division bench of the Calcutta High Court. That is, it's again your Lordship's order, Abdul Mannan Khan versus the GST Council. I would
Yes.
ask my learned junior to hand over the copy of the order. Lordship can take from paragraph page 3, paragraph 4. Let me first outline the issue. So Lordship can take it from paragraph 2 if Lordship so deems fit. We have heard the learned advocates for the parties at length. We need not labor much as to what relief the appellant would be entitled to. In the instant case, we are guided by 2 judgments of the division bench. One of the Jharkhand High Court, other one is of the High Court of Odisha. Case of Mahalakshmi Infra, so and so, the court considered an identical issue and granted relief to the assessee in the following terms. Having gone through, should I place?
Yes, yes, yes.
Having gone through the decision cited in support by the learned counsel for the petitioner and that the instant case does not present any additional tax impact, all loss of revenue for the state exchequer, and in fact, such correction of relevant returns in case of petitioner, that is GSTR 1, GSTR 2 in case of respondent number 5 and 6, would allow the respondent number 5 to rightly avail the ITC against the tax paid under the tax invoice number so and so, issued by the petitioner. We are of the considered view that interest of justice would be served if the petitioner is allowed to make the necessary correction in GSTR 1 form for January 2019. Such correction, if does not entail technical difficulties by the GSTN, may be allowed to be made online by GSTN by opening the portal for a limited period upon due communication to the petitioner. And respondent number 5 and 6, as it would reflect corresponding correction in the GSTR 2A form for the relevant period. That is automatic. If I file a 1, the 2A will be auto-populated.
Yes.
If such a course is not possible to be done online, thereafter identical issue was considered by the High Court of Odisha. And thereafter the High Court of Odisha's observation is cited. And finally, my lord, at page 5.
Yes.
Finally, after citing the Odisha High Court's judgment, our Honorable Division Bench at page 5, paragraph 22, my lord, the Honorable Division Bench of High Court of Odisha, taking note of the decision in Sandai Chemical Supra, permitted the petitioner before it to resubmit the correct GSTR 1 form. And to enable the petitioner to do so, and direction was issued to the respondent to receive the same manually. And once the forms are received manually, the department will facilitate uploading of those details in web portal, and a time frame was also fixed for carrying out the directions. The underlying principle based on which such direction was issued in the aforementioned judgments is that the assessee should not be prejudiced from availing the credit which they are otherwise legitimately entitled. Therefore, we are of the view that appropriate directions have to be issued in the case on hand so that the appellant would be entitled to avail the credit which he is legitimately entitled to. In the light of the above, appeal stands allowed. Order passed in writ petition set aside. Writ petition stands disposed of by directing the appropriate respondent to permit the appellant to file corrected GSTR 1 form manually, and the appropriate authority of the respondent department is directed to receive the forms manually, and requisite details shall be uploaded in the web portal of the department within a period of 6 weeks from the date of such manual forms are submitted. Consequently, the connected application stands disposed of. This is our High Court, our Honorable Calcutta High Court. One matter from Bombay High Court traveled to the Supreme Court as well. There, the SLP got rejected. I will also give that Bombay High Court and the Supreme Court's order, my lord, just to cover the whole issue that it has achieved finality. Yes. Aberdare Technologies matter, my lord. I would ask my learned junior to hand it over to my lord. First, the Bombay High Court Division Bench decision. It's a 9-page judgment. Same. The points are pat on the face of the Lordship will see they have first cited an erstwhile judgment and respectfully followed that judgment. The judgment is the same. And thereafter, Lordship needs not trouble Lordship with all these judgments, but take the SLP judgment, the final SLP judgment. I would ask my learned junior to hand it over to your Lordship as well.
Yes.
The SLP of the Aberdare.
Yes, yes.
Here, my lord will kindly see. Upon hearing the counsel, the court made the following order. Delay condoned. We are not inclined to interfere with the impugned judgment, which is in fact just and fair. And there is no loss of revenue, hence the present special leave petition is dismissed. The petitioner, Central Board of Indirect Taxes and Customs, must re-examine the provisions, timelines fixed for correcting the bona fide errors. Timeline should be realist, as lapse or defect invariably is realized when input tax credit is denied to the purchaser, when benefit of tax is denied. Purchaser is not at all at fault, having paid the tax amount. He suffers because he is denied benefit of tax paid by him. Consequently, he has to make double payment. Human errors and mistakes are normal, and errors are also made by revenue. Right to correct mistakes in the nature of clerical or arithmetical error is a right that flows from the right to do business and should not be denied unless there is a good justification and reason to deny benefit of correction. Software limitation itself cannot be a very good justification, as software are meant easy compliance and can be configured. This is very important, I think, my lord. Therefore, we exercise our discretion and dismiss the SLP. Decision of the High Courts in so and so and so and so, prima facie, do not lay down the good law in regard. Ratio therein may be examined in another case. So anyway, this is the final outcome of the issue, attuned to our own Calcutta High Court's division bench decision, my lord.
Yes.
So my only humble prayer is that the respondents, I have made them parties. Union of India is also a party. Let them be directed to open the portal. I can rectify my GSTR 1, or if Lordship so feels like the judgment in the Calcutta High Court, I can file a manual GSTR 1 as well. They should accept and incorporate it in their system so that the 2A is generated.
Give me a minute.
My lord.
Yes.
My lord, after this judgment of the Honorable Supreme Court, which he has relied on, the Central Board of Indirect Taxes, there was another judgment of Union of India and others versus Bridge System Limited and others. The Honorable, and this issue is pending before the Honorable.
No, but may I hand over the Bridges judgment as well? I am armed with that as well. First, Lordship will kindly take the Bridges Bombay High Court judgment, and thereafter the Supreme Court judgment. Here, the CBDT was not a party, and the Honorable Supreme Court has only said that CBDT be made a party so that they can open the portal. That is the only difference. It will also have the same consequence as the Aberdare Technologies, my lord. Lordship, kindly I'll request my learned junior to hand over the Bombay High Court judgment and the SLP of the Bridge Mohan. Mohan to na ki jano? Bridge Systems. The last one paragraph is very important.
Which judgment?
The judgment that my learned friend is showing.
Yes.
It may be noticed that in all these cases, it is accepted by the revenue that there is a clerical or arithmetical mistake, which is not being permitted to be corrected. Invariably, such mistakes come to the notice of the seller who has filled up the online forms, etc. after the ITC is denied to the purchaser. We appoint Mr. Datar, learned senior counsel, as an amicus curiae to assist the court in the present case. Here it is only, and over that paragraph, however it appears, on account of mistakes of errors getting noticed on the input tax credit, the ITC being subsequently denied to the purchaser, revenue has been taking the stand that rectification is not possible after expiry of the period in 37.3 and 39.9. In order to resolve the issue, we deem it appropriate to issue notice to the Central Board of Indirect Tax and Customs. Here, CBDT was not made a party, and that is why they have asked to make CBDT a party. Otherwise, how can the direction to open the portal be given, my lord? While in Aberdare, CBDT was already a party. In fact, CBDT only went up in appeal. In Aberdare, CBDT only went up in appeal. And here, CBDT was not a party. That is why CBDT has been included. It will face the same consequence as Aberdare. And since this is an interim order, this, I do not think, my lord, that this has any precedentiary value. The main precedentiary value is of the our division bench, Calcutta High Court, and of course the SLP rejection in the Aberdare case.
Yes.
My lord, the question which was raised by the revenue was that the revenue has been taking the stand that rectification is not possible after expiry of the period prescribed under sections that 37(3) and 39A of the Central GST Act 2017. In order to resolve the issue, we deem it appropriate to issue notice to the Central Board of Indirect Taxes and Customs. My lord.
No, that
This
issue is
whether
resolved.
the limitation can be condoned or not, this issue is still being pending before the Honorable Supreme Court, and hence I pray, my lord, kindly the matter may be kept pending, my lord.
My lord, that issue is already resolved in Aberdare. May I once again place Aberdare the Supreme Court's judgment, my lord?
No, but yes, that is so. But
Yes.
now in the
My lord, the
subsequent decision, the Honorable Supreme Court has felt that since that revenue has taken that stand, and in order to resolve that issue, this matter has been kept pending, and an
My lord,
amicus
that is
has
because
been requested
that is because
to assist the court.
My lord, that is because CBDT was not made a party in that matter.
No.
Bridge bridge systems
No.
case.
Maybe, but if that is so, the Honorable Supreme Court took note of this Aberdare judgment, wherein CBDT was a party. The Honorable Supreme Court could have observed, no, CBDT was a party and this matter, because the second paragraph, we do not find any merit, as we have already dismissed.
That is the main catch line. We do not find any merit in the present
Mr. Bhattacharya, only one thing.
My lord.
37(3) and 39(9) was not considered by the Honorable Supreme Court in Aberdare judgment.
My lord, that was considered in the Bombay High Court division bench case.
But Honorable Supreme Court did not consider that. That might be the reason why the Honorable Supreme Court fixed this matter and appointed an amicus.
My lord, subject to correction from your lordship, lordship will kindly see the judgment of the order opens like, we do not find any merit in the present special leave petition, as we have already dismissed so and so. Now CBDT is made a party to issue instruction so that that portal may be opened, because unless CBDT is made a party, nobody can open the portal. That is why they are firstly spelling out that we are not finding any merits in this instant case, but we are making party to CBDT because CBDT is not there. Your lordship will see. Otherwise, the first two lines are
yes,
ocious.
you are right. CBDT was not there in the other judgment, but
in the other judgment, CBDT was there.
Yes, in bridge system, CBDT was not a party.
Not there.
But in Aberdare, CBDT, it was an appeal at the instance of the CBDT.
Yes. And that got dismissed.
The Supreme Court, even after taking note of Aberdare's judgment, thought it fit to appoint an amicus to assist on the issues as to whether it's possible to.
My lord, that is again because the CBDT, unless it is incorporated, the order cannot be given to CBDT to open the portal. And that is why the first line says we do not find any merit.
No, Mr.
And so much so that, my lord,
to open the portal, amicus is not necessary.
No, amicus is not necessary. That is
so.
True.
If that is so, that cannot be a ground, because in the earlier judgment, it has been said that cannot be a ground. Software limitation itself cannot be a ground.
My lord,
so that was made clear. So that cannot be a ground for keeping this SLP pending and appointing an amicus.
My lord, only subject to your lordship's consideration. What I am on is that this matter
Mr. Bhattacharya, this has
an
been
interim order.
Mr. Bhattacharya, this has been fixed only on 28th of April 2025. So
but, my lord,
I can place it before
the matter, if the only problem is once this matter gets slipped over, my lord, it is very difficult to bring it on the list.
Bhattacharya, this is a vital issue, and this a larger bench.
My lord, may I indicate one thing? May I indicate one thing?
Issue to be decided 37(3) whether this timeline can be extended or not.
May I indicate one thing?
And this is a subsequent decision.
Yes, may I indicate one thing? Subject to correction from my lord. May I indicate one thing? My lord, here, whatever the last day I argued, I would like to adopt the same argument. It is an interim order. It has got no precedentiary value.
No.
While our division bench,
Mr. Bhattacharya, when this issue has been framed, so the question is whether these timelines can be extended or not. This issue, when it is pending before the Honorable Supreme Court, it has to be adjourned. It has to be adjourned because this is an issue which is to be decided.
If my lord is of that
And,
opinion, my lord, I will.
Because the other issues will be whether dismissal without giving any notice to the other side in Abad's judgment, whether it amounts to merger or not, that also is a question to be considered.
Yes, and also the same, lordship will
So
kindly
if it is
see
not a
here.
merger, then it's only a division-based judgment of the Bombay High Court. And here the Honorable Supreme Court has raised a point. And even after considering the fact that CBDT was a party in the Abad's judgment, took note of that, even then felt that this issue is to be decided.
But there again, my lord, the first two lines, it says that we do not find any
What
merit
was
in
the
the
occasion,
present.
Mr. Bhattacharjee? Then, first two lines, it could have dismissed because CBDT was a party, his stand was made clear, everything was decided.
Probably the Honorable Supreme Court wants to settle the law once and for all.
Once for all.
Once and for all.
Mr. Bhattacharjee, you know, dismissal of an FSLP does not amount to.
That does not amount to a precedent.
So,
Does not amount to a precedent.
it's in that, on the facts of that case, the Honorable Supreme Court failed, but now the issue is with regard to limitation.
But my lord, our division bench judgment is there, lordship will kindly
The
consider.
Supreme Court has raised an issue with regard to that. Our division bench is there.
Our
I'm
division
not
bench judgment is
foreclosing
there,
your
my lord.
right. I'm keeping it pending. I'm not saying that in view of this, you do not have any right. I'm keeping this matter pending because the issue is before the.
Then, my lord, let me be given an opportunity of submitting this annexure that I missed, my lord, by way of a supplementary.
That you can do by way of an annexure.
And the same maybe we not serve to my advocate on record. But I am appealing for respondent number 6.
I am led by you, Mr.
As prayed for by Mr. Bhattacharjee, learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit annexing the this is the impugned order.
Order dated August 10, 2022.
Annexing the impugned order dated August 10, 2022. First of all, the issue that arises for consideration in this writ petition is whether the rectification of GSTR, all capitals 1, GSTR 1, can be permitted after expiry of the time limit stipulated for correction of such mistake. First of all, in the impugned order, it has been where section 37 has been referred to that it cannot be done.
August 10, 2022 order, second page, my lord.
Second page. That has been quoted.
And thereafter, at the bottom, lordship kindly sees, just before the table.
Thus, the time limit is.
Thus, in consideration of the inadvertent mistake, and thereafter, in the instant case, the time limit for rectification was given as below.
Yes.
My lord got it.
Yes, yes.
Period which November 2018.
Yes, that is the period. Thereafter
Yes.
was ever but did not rectify.
Yes.
Section
Within the
6 provides
stipulated
a
time.
time limit as per the section 6 and 7. Thus, the time limit of availing in respect of the supply is not shown in the petitioner. RTP is also, in other words, were not claimed within the time limit. In the impugned order, this is the adjudicating authority or the appellate authority?
This is just an authority, my lord, the jurisdictional authority, I must say.
The jurisdictional authority, after noting the provisions of section 37 of the Central Goods and Service Tax Act 2017, corresponding to West West Bengal Goods and Service Tax Act 2017.
But my lord, may I submit one thing? It is only
Yes.
that they have cited section 37 but made use of section 39 actually.
Yes. And section 16 within bracket 4 of the 2017.
No, my lord, that is a different proposition. 16.4 I am not on it. 16.4 is for the respondents to answer.
So you are on this 37.
37, 39, because if I get it corrected, the
Yes.
pro forma respondents actually 16.4 has already been done away with.
All right.
16.4 has watered down by
Section
incorporation of
37
16.5.
of the 2017 Act has corresponding West Bengal GST Act submits that it has been held that since the prayer for rectification was made beyond the stipulated time limit, the same cannot be allowed.
Yes.
Mr. Bhattacharjee, learned advocate appearing for the petitioner, places reliance on the decision of the Honorable Division Bench in FMA 142 of 2022 in the case of Abdul Mannan Khan versus the Goods and Service Tax Council and others, order passed on March 31, 2023, as well as the order of the
Division bench of the Bombay High Court, my lord.
Honorable Division Bench of the Bombay High Court in the case of Aberdeen Technologies Private Limited and another versus Central Board of Indirect Taxes and Customs and others in writ petition number 7912 of 2024. Order passed on July 29, 2024. Submits that the petitioner can be permitted to correct the to rectify the mistakes in GSTR 1 even after the such an attempt is made beyond the time limit prescribed therefore. Mr. Bhattacharjee submits that the special leave petition filed by the Central Board of Direct Taxes.
Indirect taxes.
Central Board of Indirect Taxes.
And customs.
Central Board of Indirect Taxes and Customs in special leave petition within bracket civil diary number 6332 of 2025. Refused to interfere with the order passed by the Honorable Division Bench of the Bombay High Court. আচ্ছা ওখানে যেটা বললাম না স্পেশাল লিভ পিটিশন ডায়েরি নাম্বার বাই অ্যান অর্ডার ডেটেড করে বাই অ্যান অর্ডার ডেটেড March 21, 2025. ঠিক আছে? Paragraph. The so-called learned advocate appearing for the revenue submits that the Honorable Supreme Court in special leave petition within bracket civil diary number 6334/2025 in the case of Union of India and others versus Bridge Systems Limited and others by an order dated March 24, 2020. By an order, in which passed an order on 24th of March 2025. Paragraph. She submits that the that in order to resolve the issue as to whether rectification is permissible after expiry of the period prescribed under section 37 within bracket 3 and 39 within bracket 9 of the CGST Act 2017, the Honorable Supreme Court appointed an amicus curiae to assist the court on such issue. First up, the order dated 24th of March 2025 passed in special leave petition within bracket civil diary number 6334/2025 is extracted hereinafter. Bole na? Puro order ta ke set out kore. Supreme Court website e paya jabo. Since a legal issue has been raised since a legal issue has been raised and the same is the subject matter of consideration in this writ petition, since a legal issue has been raised by the Honorable Supreme Court in the aforesaid special leave petition, and such issue is the subject matter of this writ petition. This court is of the view that the hearing of this writ petition should be adjourned till a decision is taken, till a final decision is taken in the aforesaid in Bridge Systems Limited and others, Supra. First up, list this matter. Mr. Bhattacharya, there is no scope to pass any interim order in this.
No, it's a
There is
revenue
no
neutral
scope.
matter.
Yes. There is no scope to pass any interim order at this in this writ petition. First up, you want to file affidavits?
My lord, that will elongate the matter.
Since only a legal issue is involved, there is no necessity to file an affidavit in opposition. First up, list this matter in the available circuit bench starting from the month of May 2025.
Yes. I'm grateful to my lord.
I think hopefully 28th of April. So
Yes.
in that time,
It may
or
so
June.
happen.
Mr. Bhattacharya,
My lord,
May or June?
May. I will take my chance on in the month of May again.
Yes.
I'm grateful to my lord.
Supplementary, you have a copy of the that document, impugned order, you have a copy. For filing supplementary affidavit?
Yes, my lord, we have a copy.
Because the copy of the order, impugned order, jeta boleche na, but the copy of the such order which has been produced by the learned advocate on record of the petitioner is taken on record.
I'm grateful.
Yes.
I'm grateful.
Next. Yes. Service not been affected. Yes. You are on the state. You are for the state.
I am for the petitioner.
You have not affected service, Mr. Jana.
Effective respondents, district inspector of school state. State has rejected my higher scale of pay that is covered by the larger bench decision. Your lordship,
Yes.
kindly allow me to place
Their case is different. We need to file affidavit in this case.
What
So,
affidavit? Point out what is the distinction,
cases
why
that-
it will not be covered by the.
There are cases that after joining the service, they have taken up the higher improvement
You
of
have a
record.
copy of the larger bench judgment.
No, that is.
my lord,
So you show me which paragraph. I am making it not today. Be ready.
Lord,
Yes.
No, my lord, the paragraph my lord, I have closed my
Alright.
enclosed my lord, the identical judgment that has been quoted in the said judgment. I have
Yes.
annexed in my writ petition.
Please show it to your learned friend so that he can come ready.
That has annexed my lord, page 51 of my writ petition.
Yes, the paragraph, relevant paragraph, I am asking your advocate on record to tell to the learned advocate for the state.
Paragraph my lord, has been set out in the that judgment. Paragraph. Yes, that is page 54. That has been set out in the
Page 54, kindly look at that. I am keeping it tomorrow. Yes, next.
tomorrow.
Yes.
I'm on behalf of the state. I
Who is
received
for the
brief
petitioner?
today, my lord. I received the brief today, my lord.
None appears for the petitioner at the time of call. No accommodation has been sought for either. The learned advocate appealing for the state seeks an accommodation. Hearing of the matter stands adjourned for this week. Yes, next.
I am for the petitioner, Lordship. Lordship, here in this case, Lordship, Lordship, the petitioner is the fair price shop owner, Lordship. Subsequently, the respondent authority, a new notification has been published for new appointment of fair price shop in the locality of the present petitioner, Lordship. Lordship, that notification I have challenged, Lordship. Lordship, series of writ petition has been filed before the principal bench. Lordship, their Lordship, subsequently a MAT appeal has been preferred by that writ petitioner. A stay has been granted to upon the notification for appointment of the fair price shop, Lordship. Lordship, kindly.
What do you want now?
Lordship, my
The matter is pending before the division bench. How can this be taken up now?
Lordship, kindly peruse the page 120 of my writ petition.
Yes. What is your prayer?
Lordship,
Page 162 সেটা তো?
Lordship, page 120, Lordship, similar order I am praying for, Lordship.
Page
120 of my
120.
120 of my application.
Yes, what is your instruction?
It is still pending and we have been, similar order has been passed in other several matters. Several matters, this order has been passed.
This order?
Yes. The selection procedure shall continue.
Why this 2013, this notification, this National Food Safety Security Act, what has been done? This has been declared ultra vires.
Yes, Lordship.
Where is that judgment?
Lordship, Lordship,
Where is the parent order directing this interim order? This has been followed according to you.
Lordship, this is the first order lodged.
This is the first order.
Yes, Lordship. Whereby stay order has been granted, Lordship, in the last portion of the order, Lordship. Para 10.
Para?
10.
10 of what?
10 of the order dated 6th of August 2024, Lordship.
6th of August. Yes, where is the stay?
Lordship, Lordship, may read, Lordship, we direct none of the ration card holder shall be delinked from the dealers, and the dealer shall not be dealing from the distribution if not already done for a period of 2 weeks from date or until further order. Which was
What have been done thereafter?
Lordship, thereafter the issue has been taken up on 6th. Next will be taken up on 16th of
So
April.
this interim order is being continuing.
Yes, yes, yes.
So I'm following this interim order.
Lordship. Lordship. Lordship,
This-
here is the last order on the MAT application. Lordship. And that interim order is extended till 16th of April, Lordship.
Where is the order of the single bench? Which is the subject matter of MAT 1543. We have the copy of the single bench decision.
No, Lordship, that order I don't have. But lastly, page 120, which have been filed, Lordship, this order I am praying for, Lordship.
What?
Page 120 of my application.
Why?
Lordship, a stay on the notification is required, Lordship. Otherwise,
Why? The division bench has not passed that order.
but
I'm bound by the honorable division bench order.
Lordship, in the
That is the order passed by the honorable division bench. Where is the order passed by the single bench, which is the subject matter of MAT?
Lordship, page 120.
120.
120. Lordship. This application.
No. This is the order passed, which is the subject matter of MAT 1543. This is not that order.
No. This writ petition has been filed subsequently after
Yes.
passing the order of MAT application.
Yes. I want to know what was the order passed in which is the subject matter of appeal in 1543. You have a copy of that order?
No, Lordship, that order I don't have, Lordship.
What is the use of proceeding with this? Since according to you that has been set aside, how can that be proceeded with as per that? Do you have the copy of the judgment of the single bench? Which is the
No,
subject
Lordship,
matter of MAT?
that copy I don't
Can
have.
you get tomorrow?
Lordship, that I can.
All right.
But Lordship, one thing, Lordship, kindly once peruse the para 37 of my application.
Para 37, yes.
30,
Para 37.
37, 38, Lordship. Lordship, 38, Lordship.
36, 37.
37 and 38.
What has happened in your case? What has happened in your case?
Lordship, in my
Vacancy has been declared. Who are you?
Lordship, I'm the fair price shop owner on that locality where the notification has been published to
Where is the notification?
Lordship page. Annexure P2, Lordship, page 28.
No, why a vacancy notification has been issued? The original, the fair price license holder, he died.
No, Lordship.
Then why vacancy notification has been issued?
Lordship, that notification I have challenged, Lordship.
Why vacancy? What is the reasons for issuance of this vacancy? Where is that vacancy notification?
Lordship, Annexure P2, page 28, Lordship.
28, yes. This is which area?
Lordship, some of the portion of the present petitioners operating the fair price shop, Lordship.
Yes. So there is a vacancy. Those ration cards have been tagged with you. The original, there is a vacancy. So those ration cards holders, they have been tagged with you. That is your case.
No, Lordship.
Please come to paragraph 6. Sorry, paragraph 3. Tagged ration card holders and no complaint have been tagged. So you are not the original dealer of that locality. The original dealer maybe died or something happened. So that ration card holders of that area, that has been tagged along with your dealership. However, is saying that you are the original. That is why vacancy notification was passed.
Lordship, on that issue, Lordship, I'll take instruction from my client.
What instructions? Your statement
Lordship.
in the writ petition.
No, Lordship.
That cannot improve.
No, Lordship, kindly, and moreover, Lordship, I'll take the judgment of the single bench. Lordship,
Not
tomorrow,
necessary.
Lordship, kindly make it
Not necessary. The
Lordship,
petition
Lordship.
judgment.
I'm completely unaware about this fact, Lordship. So I'll take instruction, Lordship. Otherwise, Lordship, the petition will highly prejudice, Lordship.
I'm following the interim order passed by the Honorable Division Bench. Ashok.
Lordship.
Uh,
The issue,
the
Lordship, since the issue has been pending before the principal bench, Lordship,
what do you want?
Lordship, I want the decision of the division bench will comply on this.
Yes, yes.
So this
That-
matter also be stay till the disposal of that application.
What stay?
Lordship, upon the recruitment process to
Yes, yes. I'm protecting your interest.
Lordship.
You need not be worried. The petitioners have prayed for withdrawal of the approval of the vacancy of the fair price shop at village Para Nistaraf, Dokhin Nistaraf, Muddo Nistaraf, Nistaraf has challenged the auto likhtam has prayed for Kibulla has prayed for. Now, prayed for approval of the vacancy of fair price shop at different locations under Makliganj subdivision in the district of Kuch Bihar. Full stop. Paragraph. The learned advocate appearing for the petitioner submits that a mandamus appeal on the issue as to the mandamus appeal being emittive, a batch of mandamus appeals, the lead case being emittive 1543 of 2024. Within brackets, Shetara Begum versus State of West Bengal and others is pending before the principal bench of the Honorable High Court at Calcutta. The petitioner seeks an interim protection in this writ petition so that the business of the petitioner is not affected. The learned advocate appearing for the petitioner produces a copy of the order dated August 6, 2024, passed in the batch of appeals being MAT 1543 of 2024, wherein the Honorable Division Bench passed an interim order to the following effect. Paragraph 10 or 11 quote korben. It has been submitted by the learned advocate for the petitioner that the said interim order is being extended from time to time. The said interim order was extended from time to time, and the same shall remain in force till the end of April 2025 or until further orders. This court is inclined to, since the issue involved in this writ petition is the subject matter of the pending appeals, in the batch of appeals being MAT 1543 of 2024 and others, this court is inclined to pass an interim order in tune with the interim order passed by the Honorable Division Bench. First up, it is therefore directed that none of the ration card holders shall be delinked from the dealers, and the dealers shall not be delinked from the distributors if not already done for a period of 12 weeks from date or until further orders, whichever is earlier. In case any delinking of ration card holders and or dealers has already been done, the same shall abide. Delinking of ration card holders and or dealers has already been done, the same shall abide by the result of this writ petition. This
one line will be added that in all the cases there was direction upon the state to file the affidavit.
Let affidavit in opposition be filed within 4 weeks from date. Reply.
And another line is that election procedure shall continue. There is no state regarding the selection procedure.
I have not said anything with regard to the selection process.
No.
I have only said with regard to this detail.
Lordship,
Affidavit in opposition be filed within 4 weeks from date. Reply thereto if any be filed within 2 weeks thereafter. Parties will be at liberty to mention for inclusion.
Lordship,
immediately after.
can this order can be passed, Lordship? Lordship, page 121, para last two.
Selection process to continue.
No, Lordship.
Cannot
Lordship,
be.
Lordship, that order has been passed, Lordship. So
I am following the division bench. It's binding on. There's a single bench. If the Food Security Act goes, any vacancy in terms of that has to go. So the selection process, in the meantime, when that that Safety Act has been said it has not been implemented, no steps can be taken in furtherance thereof. Please don't ask me to comment on that. That is why I have refrained from.
Grateful, Lordship.
Yes, call the next. To mention the matter for inclusion immediately after expiry of the time fixed for exchange of evidence. Yes, call the next matter.
Lordship, affidavit.
Every service filing court today is taken on record. Yes, next.
I'm grateful, Lordship.
Call the next matter.
Item number 18. May it please your Lordship,
I'm for the
Yes.
response number 5.
item number 18, my lord, WPA 2525 of 24.
Yes.
My lord, actually, I am happy today. I just, before coming to the main points, I would like to convey before your Lordship that I am highly pleased and happy today because I find that embargo has been removed and today my case again be enlisted. That was in initial
What
occasion,
embargo?
Embargo, that is the last time it was unlisted for a certain people.
Milord,
yes, yes.
Milord, may peruse the
and-
last
and
order
today-
just. What he is saying, Milord, may peruse the last order passed by Honorable Justice Joy Gupta. Kindly see.
All right. Yes. What is this matter?
In that order, my case was unlisted. And yesterday.
What do you want, sir?
Because of some.
What do you want in this?
Actually, I want the relief as per our writ petition. 2525 writ petition. I want to get a mandamus against the wrongdoers who violated some provision of the.
Who are the wrongdoers?
Wrongdoers are, there is a 5 respondents. 1 and 2 is the state authority and 3.
What have they done?
3, 4 and 5.
Who is representing the private respondents?
I am representing respondent number 5.
These are the,
Who is you are for the municipality? Yes.
and these 2, 3 and 4, 3, 4 and 5 created that actually improvement of the roads and thereby preventing the public to get movement on that same road. That road actually situated at Siliguri.
Not the
Total
public.
road.
What is the affectation of your right? This is not a public interest litigation. sir. So what is the affectation of your right?
My right is that I cannot move through that road.
Which
Even
road?
This road where the infringement, where the encroachment has been made by these respondents. This road actually is a municipal road.
Yes.
This
No,
road
this is
only-
totally incorrect.
And
Milord, he had filed one title suit before the Lanet Civil Court.
Yes.
But after hearing meticulously, Milord, this suit has been dismissed by the Lanet Trial Court.
So these private respondents are parties.
Yes, he was party, Milord, and that land, Milord, whatever he's saying, that is my private land. Milord, he wants, Milord, he being an advocate, even the petitioner, Milord, is an advocate. Milord, he came to my house, he asked for some documents. Milord, I refused. Milord, I cannot give my documents to any random person. I refused, he went to the civil court. Milord, the civil court, after hearing all the parties, Milord, after considering the evidences, Milord, has rejected the suit, rejected on contest. That and thereafter, Milord, aggrieved by that, Milord, he has filed this writ petition. Milord, may kindly see paragraph 3 of the writ petition. Milord, what is his averment in paragraph 3, Milord? Kindly see once.
All right, come after 2.
Lordship.
After recess.
Lordship.
Lordship, may I permit to mention a matter? Lordship, matter is very urgent.
Yes, madam, where were you when your seniors matters are called on? You are sending other juniors, you are not coming.
Lordship,
Now you are coming for mentioning for a very urgent matter.
Lordship, kindly, Lordship, because the WBCL constructing a pole in front of my house that is blocking my ingress and outgress, Lordship. We are filing.
We are entitled to compensation. It's a public
No,
project.
no, Lordship,
It's a public
it's
project.
blocking my
Electrification.
Lordship, kindly fix it.
Compensation. There is a
Lordship, it's
provision.
blocking my eyes.
Your senior
cannot
argued
access
yesterday.
my house, Lordship.
Your senior argued yesterday, shown many provisions
No,
of the
Lordship.
Telegraph Act. What are the powers? How the compensation
My
is to be?
residential house blocking the entrance of my gate, Lordship. Kindly, Lordship, keep it tomorrow, Lordship. You are filing.
File it.
Yes, Lordship.
It's a new
Lordship.
motion.
New motion, Lordship.
So you, when have you filed?
Today, Lordship.
So tomorrow it will appear.
No, Lordship.
After
48
hours.
We
So it will appear on Monday.
But Lordship, in the meantime, they will
Who is for
complete
the transmission company or the distribution?
distribution company.
Not
Lordship.
the transmission. Who appears for the distribution company?
No, we are serving the copy, Lordship. Kindly, Lordship, tomorrow.
Have you filed or
Yes,
will be
Lord,
filing?
I have
How
filed.
could you file? Giving a presentation date prior to 48 hours?
Lordship,
without
in presentation
obtaining leave.
date, we have given the 48 hours time, Lordship, but I am requesting
Then
your Lordship.
it will appear as per the
Lordship,
presentation form.
if your Lordship
Lordship,
allows
my-
the leave,
My
Lordship,
submission
then
is
it will
not-
appear.
This case.
Come at 2 p.m.
After
Lordship, kindly, if your Lordship allow leave, Lordship, then it will appear tomorrow, Lordship.
But you have filed. How can I now grant leave?
Lordship, but filing number has not received yet, Lordship.
They have accepted. But they have accepted stating
No,
that for
we have
Monday.
already affirmed, but not dropped the file, Lordship.
Oh, you have not only
Yes,
affirmed.
Just,
Leave the
Grateful,
11
grateful, Lordship.
to move it tomorrow.
yes.
But
grateful.
after serving.
Lordship,
please,
we will.
tomorrow you
My lord, may it please your lordship, I have stated the activities of the respondents in my petition also. Your lordship would be pleased to see the para number 2 of my petition and para number 5 of my petition. Actually, what's happened, my lord? These respondents' list are not exhaustive, your lordship. There are several other men also who practice the same behavior there. These fellows, 3, 4, and 5 are not exhaustive. Another thing is that these lands falls within the municipal area. Ward number 2 under Siliguri Municipal Corporation is very popular place. The valuation of the land is very much high. Like, I can't say. So these valued property, what's happened? The inner portion, because I have gone through the entire lower portion level also and got the idea. So what they are actually doing that 3, 4, and 5. 3, 4 and practicing in this way, purchase a little portion of land by virtue of their sale deed. Thereafter, the practice is that after holding a 5 kata, say as for example, 5 kata land, they now started behaving, staking out their boundaries to enlarge the area of this analysis. In this way, the last 40 years, even 50 years, they're practicing like this way. And thereafter, what is the result? The road situated just on their boundary land, it becomes increased day after day, year after year, year after. And at this present moment, what happened? As I stated in my petition, these some 3 and 4, respondent number 3 and 4, fully occupied, and they successful. Then 100% they are successful. They have fully occupied the portion of the land which is the approachment road of the particular affected. I have stated in my petition in page number 32. Your lordship will please to see that. Page number 32. This is my rough case. I demanded also the original case. If the authorities are and serve the notice also. I can show the notice. I serve the, please furnish the original map of the affected road. This is the affected road drawn by me to get the actual understanding what's happened. Your lordship would be pleased that on the extent 2 boundaries of the plot, there is a Meghnasa Sarani in the one hand and another is Nivedita Road on the other hand. On the stated bed, page number 32. Between these 2 roads is a main road, a wide space. And this affected road, your lordship will please to see the inner side of the sketch map. There is a dotted point on the road. Another road is shown by me. This is the affected road. In between these 2 roads, Meghnasa Sarani and Nivedita Road. Achha. What happened, your lordship? Please, one man, Mr. Monohar Dhandania, his name also been mentioned in the sketch map. Monohar Dhandania. One part, that is the northern side. I also put the actually north, east, south, west. Lordship, please, Monohar Dhandania is a northern side land.
Yes.
And another is southern border, the Rudra Narayan Bhattacharya here, holding is there. And these 2 portions has been fully occupied. Fully, there is no passage of this road, these affected roads. Their portion is totally blocked. How can I get access? And this approachment road comes to the main road, the connecting road, but totally preventing us. to move our activity, to maintain our life.
Yes.
Lordship, road means what? Road means beside the road, there is a sewage system facility. Sewage system is prevented. No sewage system. No road means no sewage system. No road even, no sewage system. In rainy season, what happens? The filthy water will go. The possibility of the disease brought by mosquitoes, dengue, malaria, etc., etc. These things are common. We are suffering a lot during last, say, about 40 years. The locality, I stated in my petition also, the local man being aware of this fact, approached this gentleman. I stated in my plate. But no remedy. After that, what happened? We served a notice. Now, before that, I got the information from the local person. Yes, it's happening. Yes, I am getting that access is prevented. Yes. I brought a suit for getting whether these persons who actually occupied this land, they are holding by virtue of their ownership right or not on that property. In order to get that idea, before coming to the writ petition, I actually inquired the matter to legal proceedings. I brought a suit under declaration, only just declaration suit against the this one man, not all the a token test, just one against one man, that is Manohar Lal Dandani, not the other respondents as stated in our writ petition. One Manohar Lal Dandani was subsequently appeared, filed written statement. In his written statement, from his written statement, we got the idea, yes, he is not holding any right title interest of their holding, of the enclosed land. It is admitted fact, Lords. I can show in the paper, I have furnished several papers.
No.
So these papers are all judicial papers, and these papers will show the subsequent order was passed depending upon our page number 17. Your Lordship will be pleased to find the page number 17. We just demanded for inclusion of certain names of the authorities in that suit. In the initial occasion, we did not file the authorities because we need the actual position of the land, how they are holding that property. So at that time, we did not feel sufficient to inform the matter and to bring that state authorities in that declaration suit. So we just filed case against the Manohar Lal Dandani, not against the state. So at the very first occasion, we failed to mention the name of the state in the declaration suit. And subsequently, we thought that page number 17, your Lordship would be pleased to go. Page number 17 is that pages wherein we prayed for injunction, inclusion of the names of that state authority in the declaration suit. And law is very much clear. 90 Supreme Court is there. I am Albanian clean hand. I am also clean hand. All these things are satisfying. So let there be an order for inclusion of this name in the declaration suit. What is the consequence? Your Lordship would be pleased to see that papers, subsequent 2 orders has been made out by the lower judgment.
No, I cannot test the correctness of those orders.
No.
In this writ petition.
Yes, yes.
So whatever.
I'm shortening the matters. Yes.
Now, what do you want in this writ?
Yes, yes. I'm giving the clear picture. I'm shortening the matter. And these, depending on this thing is very vital and very relevant. That's what I mean. Subsequent 2 orders. Moreover, in this case, no evidence has been taken up. No evidence, no oral evidence, no witness, nothing.
Sir, I cannot go into the
propriety
of the order passed in a suit.
Let me allow.
I cannot go to the propriety of the order passed in a suit. What do you want in the writ petition? Please come straight away.
I am coming to that, that portion. Now I am aggrieved because of my infringement of the right to access and the right to life, as well as the direction of the states also. I filed this petition depending upon the provision of 19(1)(d), 21, that is the protection of life, and the 38(2). As your lordship already knows, there is a very important judgment given by our apex court, headed by his lordship Sabyasachi Mukherjee in the area of 1986 and associates. I have
So you want removal of encroachment?
no, depending on the
Yes. So you
on
want,
that judgment,
sir, you
their
want
lordship was pleased to consider if
you
there is
want
a violation
removal of encroachment from
from
the
affected
public-
road,
from the public road.
from the affected road that is falling between the Nivedita road and the
According to you, that is a municipal road.
municipal.
Let me hear them. Yes.
Acha. Okay, again another few lines with permission. And these authorities being even aware of the fact,
Have
even
not
after-
taken any steps.
even having received the notice, one after another, even being deputed their person as a councillor or commissioner like that, annual 5 years franchise is there. So that councillor or commissioner is responsible to look after this. A law is very clear, West Bengal Municipal Act, and there is guidelines are given. So state has given all these, has taken all effect that yes, in this case, what can be done by the concern. But these 1 and 2 respondents, they are mostly responsible.
All right.
Because
So
even
let-
after
let me
guidance
hear
of
them.
the state, they are not following the
All right.
rules of the law.
Yes. Yes, Mr. Thor.
My lord, I am for the respondent number 5.
Let me hear the
Oh, yes.
Mr. first. Yes.
They have not sent, they have only sent a notice under section 80C of the CPC upon the corporation.
Yes.
This, whether it's a road or this is a private land of the belongs to the PWD.
It's not the municipal road.
The PWD.
You disclose your stand in the affidavit. Yes, what is your submission?
My lord, whatever my learned friend has submitted, my lord, that is not supported by written pleadings.
That is not supported
Supported by
by,
written pleadings. My lord, in the writ petition, in para 3, my lord, kindly take a para 3 once.
yes.
My lord, he says in para 3 that the local persons have already their grievance on above issue, but due to their individual economic hardship, paucity of funds and sufficient time in hand, could not raise their voice at court level. However, the applicant being aware of the facts and circumstances took legal steps by filing one declaration suit OC number so and so, just to know whether respondent number 3 has been possessing any sale deed to establish right title and interest or not. Now, my lord, in the writ petition, he do not disclose that his rights have been infringed, his fundamental rights have been infringed. And my lord, this is not a public interest litigation. So, my lord, whatever submission has been made at the bar, my lord, is not supported by the pleadings in the writ petition. First. Second, my lord, he has categorically stated that the value of the land is high. So, my lord, that is the subject matter of the writ petition and, my lord, filing of this writ petition. My lord, he has approached the learned civil court. The civil court has heard everything at extenso and says that he has no jurisdiction to prefer this civil suit. That has been dismissed. My lord, thereafter he has come before this honorable court. Now, my lord, there is no, my lord, iota of truth in the instant application. First. Second, my lord, I am a very respected person in the locality. I am a doctor by profession. And my lord, there have been 3 instances where he and his brother, who is the petitioner, my lord, they have come to my premises. They have intimidated me. They have asked for my documents and many other things, my lord, which I do not want to disclose in court. My lord, when I failed to his demand, my lord, he filed the suit dismissed. Thereafter, this application, my lord. So, from the writ petition, my lord, there is no cause of action, my lord, at all. And this writ petition itself is not maintainable as a writ petition. It should be a public interest litigation.
All right.
My lord, can I get one support? My learned friend again and again submitting that public interest litigation, but I am not aggrieved on the decision of the state. I am aggrieved on the activity of the state personnel. So whatever be the policy of the government, that is okay for me also. So I am not aggrieved I should bring a public interest litigation.
Petitioner has alleged that the private respondents have encroached upon the municipal road at Pradhan Nagar under ward number 2 of the Jalpaiguri Municipal Corporation. First of all, the petitioner has alleged that the private respondents, after purchasing a plot of land, have erected a construction by encroaching upon the municipal road. Paragraph. It is not in dispute that the petitioner filed a title suit number 96 of 2021, praying for where is your plaint? Have you annexed the plaint?
Yes,
Page, yes, yes, I've got that. Yes, I've got. Kilo, again, bringing it against the respondent number 3 hearing, praying for declaration that the third respondent hearing has no right, title, interest, possession, and or occupation beyond the area mentioned in the same deed. The petitioner has also prayed for a direction upon the has prayed for a decree to the effect that the illegal possession or occupation of the land held by the third respondent is liable to be vacated and to be freed from public road purpose. Stop. The petitioner also prayed for a direction upon the Jalpaiguri Municipal Corporation to take measures for vacating or removing the obstruction on the land. Stop. The suit property, which is the subject matter of the suit, has been mentioned in the schedule of the plaint. As will be evident from the schedule of the plaint that the suit property is 18 feet wide road upon which the defendant has constructed a boundary wall at the western part of the defendant's building. The said suit was contested by the private respondent number 3. The learned civil judge Senior Division Shiliguri by a judgment and decree dated April 9, 2024, dismissed the said suit on
Rejected.
rejected the said suit on contest upon holding that the plaintiff, that is the writ petitioner hearing, has no cause of action for filing the said suit. First up, the petitioner thereafter filed this instant writ petition impleading the Shiliguri Municipal Corporation and the subdivisional officer, praying for a direction upon them to remove all sorts of encroachment from the alleged municipal road falling within ward number 2 of the Shiliguri Municipal Corporation. First of all, paragraph. The learned advocate appearing for the Shiliguri Municipal Corporation submits that the road from which the petitioner has prayed for removal of encroachment does not belong to the municipality. First up, paragraph. The learned advocate appearing for the private respondent submits, appearing for the respondent number 3 submits that the petitioner is trying and has filed this writ petition in order to harass the third respondent. First up, he submits that the instant writ petition is not maintainable as the suit filed on more or less, now the suit claiming more or less identical reliefs have been dismissed by the civil court. First of all, paragraph. Heard the learned advocates for the parties and peruse the materials placed. First up, after going through the averments made in this writ petition, this court finds that no material has been produced by the writ petitioner in support of his case that the road on which there has been encroachment, there has been an alleged encroachment, belongs to the municipality. First up, paragraph. It appears that there is interstate civil disputes. There are interstate disputes between the private parties and the civil court, for which the petitioner approached the civil court and the learned civil judge dismissed the suit filed by the petitioner. First up, for such reason, this court is not inclined to grant any relief to the petitioner. First up, however, this order of dismissal shall not prevent the municipal authority from removing any encroachment upon the municipal road,
if any.
if any.
I'm
With
grateful.
the above observations.
Time bound. There.
I'm
Yes,
grateful.
sir, they will do their job. Yes, next.
I'm for the respondent's lordship.
Yes.
Lordship, in this matter, I'm praying for one day accommodation.
Why?
Lordship, on the next earlier occasions also they prayed for adjournment, Lordship. Lordship, Mr. Ghosh is not present today. Kindly fixed in Monday, Lordship. Fix this matter on Monday or Tuesday, any day, my lord.
As paid for by the learned advocate for the petition, list this matter on Monday.
Great,
Monday,
Lordship.
Tuesday, Tuesday. Yes, next.
Sure, for the information. Yesterday, this matter was part heard.
Yes. Where is the university?
The college is here.
Yes. Where is the university?
I am for the university, my lord.
Where are you? You are not
I
visible.
am for the university, my lord. My lord, my lord, before going to the kindly come to page number 58, my lord.
Yes.
58, my lord.
Yes.
My lord, last paragraph.
Yes.
Okay, last before one, my lord. In view of the aforesaid scenario, it appears that petitioner cannot be treated have qualified as 6th semester examination. Therefore, the pair which has been made, that is right, my lord. Next para, my lord. First, in terms of this order dated 21st May 2024, petitioner are required to sit in 4 papers of 5th semester, my lord, which is be held on such and such. And if they qualify of those 4 papers, the under 5th semester examination, then there will be declaration for result 6th semester, my lord. If they are qualified the 5th semester, on that occasion, my lord, 6th semester result will be.
Yes.
That is the right, my lord. So, my lord, in the 5th semester, out of 4 petitioners, my lord, 3 are compartmental. The result has been published in the month of January, my lord.
January results have been published.
Of
those 4 papers of the 5th semester.
Yes, my lord.
In respect of which petitioners?
My lord, 4 petitioners also.
All the petitioners.
Yes, my lord.
They have what is the result? They have passed.
My lord, actually, according to rules, my lord, they are eligible for sit the 6th semesters and results should be published. But
no, what is the result of the 4 papers in the 5th semester of these petitioners? Tell me
my
that
lord,
first.
My lord, they are qualifying with the complemental paper will be held. They should be sit again. But there is no problem to 6 semesters.
So where is the result? Show me the
My
result.
lord, that has been published, my lord. That is already given to the college.
Yes, college. 5th semester result. Now the ball is in
Promoted
your court.
with the back paper, my lord.
Play with the straight bat. Ball is in your court now.
Lordship, the result was published on 10th February. This is the.
So it has been published.
Yes, Lordship, portal. But the 6th semester, which we have already given
All right.
the 1 year.
So 5th semester, you have qualified.
Now the 6th semester is not
All
public
right.
result.
So now 6th semester. So now they have qualified in the 5th semester. So 6th semester results, please publish.
My lord, kindly allow me, my lord.
Yes.
If we are ready to publish the result, my lord, 6 semesters. But in the event, in the February 2025, the result of the 5th semester will be published, has already been published.
Yes.
If we, according to scenario of this petition, my lord, if we are result has been published in 6 semesters in the year 2023-24, that means, my lord, they face difficulties. The student of this university will face difficulties because the result of the 6th semester will be published now, my lord. Then that has been affected in the 2022 and 23. 23-24. That is the difficulty, my lord. We have no objection to.
difficulty, sir. I will look into that difficulty. First, publish the result. I will take it. I will see what is the difficulty.
My lord, if,
Publish the results.
my lord,
when you
according
will
to
publish the results. The difficulty will come later. Please publish the result.
yes, man, there is no problem, my lord. I will publish, my lord. Kindly,
When you will
one
publish.
thing, my
Sir,
lord, kindly
when
one
you
thing.
will publish.
My lord, if you directed me, there is no problem. We will publish.
Yes. So publish by Monday.
My kindly give me 7 days, my lord.
Why? Everything is ready. You publish the results.
But the student of the college, my lord, they are facing difficulty in future because.
All right, I will consider that. Please publish the result first. The difficulty I will take into consideration. I will see that they will not face any difficulty. For that, you are there. You will solve the difficulty.
That is right, my lord.
Being the university, you are the guardian of the students. So you will
That is
solve
right.
the difficulty.
No, my lord, actually problem is that.
Create difficulty, try to
No,
solve the difficulty.
No, my lord, I am not creating. I am not creating. Kindly hear me, my lord. Only 1 minute, my lord.
First publish the 6th semester result. I will see thereafter.
My lord, then the result will be according to the calendar of 2023-24. Before passing the 5th semester. 5th semester has been published on February in this year.
Yes.
If I publish that 6th semester, my lord, before this year,
not
my
yet
lord,
published the results of
that
the
is
6th
right.
semester.
No.
That is
You have
right.
not yet published.
No.
And you have now, as on today, you have published the 5th semester. So you cannot publish the 6th semester at an earlier date. Please
My lord,
don't say these things.
No, my lord, kindly hear me, my lord.
Yes,
My
please
kindly
publish the
one
results.
line.
Please publish the results. I will hear you. First,
Yes.
publish the results.
Yes, man. That.
Lordship, kindly see one indulgence, Lordship.
Yes.
Page 55, last paragraph.
55.
55.
Yes.
Last paragraph of the order of the coordinate bench. It is made clear that if the university for any reason fails to declare result of 5th semester, the petitioner shall be allowed to continue their studies in the 7th semester. We are studying, Lordship.
All right.
But the
There is
6th
no
semester, we are
6th semester they will publish.
because we are not able to sit in, we are not given the chance to sit in the 7th semester. At
All
the
right,
6th
let
semester.
me-
That's the point.
a coordinate bench passed an order on December 24, 2024 in WPA 2696 of 2024. The relevant portion of such order is extracted hereinafter. বলে এই পেজ 57 থেকে মাত্র পোর্শন The petitioner alleges that though the petitioner has participated in the four papers under 5th semester, which was held in the month of January 2025. The results of such semester was not published.
Now it has been published.
After this writ petition
After
was not published. When it has been published?
10th February.
So when did you file this writ petition?
Writ petition filed, Lordship, March. 18th, the result was published on 18th March, but in portal they have showing that 10th February.
Full stop. the when this matter is taken up for hearing, the learned advocate representing the university submits that the results for the 5th semester of the writ petitioners has already been declared. The learned advocate appearing for the petitioners, however, submits that the results of the 5th semester of the petitioners were declared after the filing of the writ petition. However, the fact remains that the results of the 6th semester of the petitioners is yet to be published. First up, the petitioners appeared in the 6th semester examination, and the last date of such examination was June 27.
No, sure, it will be 24.
June 24, 2024. First up, the learned advocate appearing for the university submits that the results of the 6th semester shall be published shortly. First up, the university is directed to publish the results of the petitioners for the 6th semester on or before April 7, 2025.
Kindly give me more 2 days, my lord.
No,
If possible. Kindly give me two.
You have carefully used the expression if possible. I'm saying that is not possible.
Coming in the weekend, my lord, Saturday, Sunday.
One day, everything is ready. Please publish the results. If you can do it by more 2 days, you can do it by Monday also.
Results for 195 colleges under.
But actually, they had the weekend, my lord.
List this matter on April 8,
Grateful, Lordship.
2025 under the heading for orders. Order. Yes.
Grateful, my lord.
Yes.
21 when Mr. Jana is appearing.
Yes, Mr. Jana. Yes, Mr. Shah.
Page 25.
The instruction is on the way.
My lord, day before yesterday it was heard, page 25, my lord's order. After your lordship's order, they have, my lord, allowed me to deposit the government share with interest. Thereafter, PPO has been issued.
All right, Mr. Jana, the instruction, Mr. Shah, it's on the way from Alipur.
I want interest from the date of my application after the division larger bench judgment. What
Alright,
instruction you will take?
We will get his instruction tomorrow. Yes. Next.
Tomorrow, my lord, very well, my lord, tomorrow. Tomorrow,
Yes.
next is also same.
Next is same tomorrow. Yes, next. Yes, Mr. Pal, you have got instructions. State Bank of India. You have got instructions. Yes. What is this matter? Short Passover. All right. Passover. Next.
I'm appearing for the petitioner, Lordship.
I am for the rest.
Junior yes. Where are the juniors? My lord, this matter is again another covered matter, my lord. Last day only your lordship has, last day only your lordship has decided that issue. This
What
is
issue?
107 subsection 4 limitation. This
Limitation.
limitation. And there is also another short point, although they have not pressed it hard. It is there in the impugned order itself.
But if the limitation point, then they have to appeal is to be hard on merits.
Right. Yes. And
So-
my appeal is a manual appeal because this is a Tran 1 appeal. So only manual appeals can be filed. There is a notification as well. Probably the authority did not see.
So where is the order of the appellate authority?
Yes, my lord,
Have you
page
got a
74 it
copy of
starts.
the yesterday's order?
No,
Yesterday's
no, my lord, it is not yet on the server. Otherwise, I would have put it forth. Page 74 is the order of appeal. The relevant portion will be page 85 and 86.
Page 85, 86.
85 and 86. I will place it for your lordship's reference. My lord, 5.7, paragraph 5.7. By following above judgments.
Yes. Ashun.
Yesterday's WPA number was 1829 of 2024.
WPA?
1829 of 2024. Item number was 40.
1829 of 2024. Section 5.
Item number 40.
This.
So, paragraph 5.7 deals with limitation, and the next page, paragraph 5.9.
The order of the appellate authority dated, what is the date?
My lord, the date of the order is, I will presently supply.
Page 74. 75. The order of the order dated January 29, 2025, passed by the additional commissioner, Shiliguri Appeal Commissionerate, Shiliguri, is under challenge in this application under Article 226 of the Constitution of India. First up, by the said order, the appeal filed by the petitioner under Section 107 of the Central Goods and Service Tax Act 2017 was dismissed on the ground that the same was not filed within the prescribed time limit as provided under Section 107 within bracket 4 of the 2017 Act. Stop. Paragraph. Mr. Bhattacharjee, learned advocate appearing for the petitioner, submits that it is now well settled that the you have filed an application for condonation of delay.
Yes, that was filed, and it is in the manual form, my lord. The only thing
All right,
is,
so
yes,
submits that it is not well settled, submits that an application under an application for condonation of delay under Section 5 of the Limitation Act was filed, but the same was rejected on the ground that the appellate authority cannot extend the time limit for preferring the appeal.
My lord, one thing, because the filing of, there is a filing of train 1 by the Honorable Supreme Court after that the notification.
Yes.
To claim the train 1. But filing of appeal, there is no provisions, no such decisions made by the Honorable Supreme Court.
For what?
For filing the manual appeal.
No, that is.
I'm not going to that, only with
again on that.
No, my lord, manual appeal, they have a notification. I have annexed the notification.
Sir, I cannot go into that because unless the Section 5 is considered, I cannot go into the merits. That is the difficulty.
My lord, not on merits. It was done away with summarily, since it was also filed in a manual format. Just lordship will kindly take paragraph 5.9 once.
5.9, yes.
Yes, page 86. I find that the instant order for cancellation of registration is available in the BOWeb portal. Further, no notification for accepting manual appeal issued by the commissioner is found to be available.
Yes.
And therefore, I summarily reject. There are 2 reasons for summary rejection. These are the 2 reasons. And the notification is appended at page 89. Lordship kindly sees the notification, page 89. Probably they have missed that notification. In the very first paragraph, it says, in exercise of the powers conferred by so and so, the central government, on the recommendation of the council, hereby notifies the following special procedure to be followed by a registered person or an officer referred to in subsection so and so of the said act, who intends to file an appeal against the order passed by the proper officer under 73-74, pursuant to the directions of the
Shall be
Honorable Supreme
presented
Court.
manually before the appellate authority.
Manually.
What do you say to this?
This is their
I
notification.
will
only.
direct them to take into consideration this notification.
My lord, let them hear my appeal on merit, my lord. There is no harm on that.
Let them consider this aspect also.
Because manual appeal and portal appeal are no way different.
That is.
It is
yes,
only.
Sir, what do you say?
Yes.
This notification may consider by the authority.
This notification permits manual.
Manual. Actually, it prescribes manual
you see,
filing.
there is no provisions
Alright,
in the portal.
Akula? Time limit for filing the appeal. For preparing that. Mr. Bhattacharya further submits that the said appeal was also dismissed on the ground that the same was filed manually on the ground that there is no notification for accepting such manual appeal. Mr. Bhattacharya placed reliance upon a notification dated July 31, 2023 in support of his contention.
My lord, bearing
that,
number 29 of 2023.
Notification being number 29/2023 central tax.
Yes.
Dated July 31, 2023. That an appeal of such nature can be presented manually before the appellate authority.
My lord, shall be, because there is no other provision. Shall be. An appeal against that order shall be made in duplicate.
Paragraph. With regard to the issue as to whether the provisions of Section 5 of the Limitation Act shall be applicable for condonation of delay in preferring an appeal under Section 107 of the 2017 Act. কি বলে শুরু করলাম? With regard to the issue as to whether was considered by this court in a writ petition being OWPA calculator.
1829 of 2024.
Wherein this court by an order dated yesterday, it was
My lord.
calculate date wherein this court by an order dated yesterday's date passed the following order. The relevant portion of the said order is extracted hereinafter. First up, in view thereof, this court holds that the for such reason, this court is inclined to interfere with the order passed by the appellate authority, thereby rejecting the appeal on the ground of limitation. First up, the application for condonation of delay is restored to the file of the appellate authority. First up, the appellate authority shall decide such shall consider such application on merits and decide the same in accordance with law after giving opportunity of hearing to the respective parties. First up, insofar as the ground of rejection of the appeal insofar as rejection of the appeal on the ground that the same was filed manually the appellate authority shall take into consideration the notification being number 29/2023 Central Tax dated July 31, 2023, and consider as to whether whether manual filing of such appeal is permissible full stop. So with the above observations and directions, now the impugned order is set aside. Mr. WPA
My lord,
582 of 2025 stands disposed of with the
one
aforesaid.
small indulgence,
Highly
my lord.
Yes.
That is since it is a Tran 1 appeal, I cannot file it through the portal. There is no option for me to file it through the portal, and that is why they have come up with this circular so that I can file it manually. Now, my
Yes.
lord,
They will consider that. You impress upon the authorities, Mr. Bhattacharya, you have some duty.
There is direction also by the my lords.
I've said they will consider that. Now it's up to you to convince the appellate authority.
No, definitely.
Everything cannot be done from here.
I will
You have
not
to
be
do
there
something
before.
there.
I will not be there before
No,
the
my lord,
appellate
we
authority.
follow the
My lord.
direction of the honorable courts in most of the cases.
I hope my learned friend will also extend his cooperation as he always does.
Definitely, we always.
Yes,
Grateful.
call the next matter.
And my lord, one very small indulgence, lordship. That is the hearing matters. If lordship kindly takes up, there are so many hearing matters in the list
Mr.
itself. I have.
Bhattacharya, I can take up, but if you agree that motions will not be taken up.
My lord, I understand
Yeah,
that
cannot be
difficulty
taken up.
as well. I understand that difficulty as well.
Mr. Bhattacharya, I have no difficulty either taking up motions or hearing. Within the time limit, I can take up. I have no difficulty. It's up to you. You have to decide whether the motions are to be given preference or hearing.
My lord, I will once again try.
I'm always hearing.
Yes.
Yes, hearing is always better because it gives the personal satisfaction.
Many
as well.
matters are hearing. I have the same thing.
One day can be designated for the hearing.
For the hearing, if that is
Because
done, my lord,
otherwise-
will be
Otherwise, from the years to so many months, hearings are.
yes. And all of
there
these,
before the next circuit bench.
my lord, all of these are ready matters. All of
Yes.
these are ready
Two
matters.
matters I argued, concluded, other side.
Or this.
My lord,
or
all
the
are,
second half.
my
That
lord,
can
they
be-
want, they
Yes,
intend to torture you, my lord. All the lawyers, they intend to torture you, my lord.
Learned AG will always
Mr.
extend his
AGP is
support.
there.
That is,
Yeah, my lord.
the only difficulty is that motions, because there are many motions which are not taken up. Motions are to be given priority. That is, yes. Maybe
Lordship will kindly consider.
something will happen in coming months.
Yes.
Let's see what happens.
Very well.
Yes.
Grateful to my lord.
I got the
Grateful.
We
petition.
are hopeful.
Yes.
The issue is, my lord, whether
My lord,
substitution-
before my lord, Mr. Ray begin, my lord, may I kindly accommodate me for a day, my lord, because of my I'm keeping annual, my lord. Tomorrow I will place all the records and documents, my lord. I think Mr. Roy and Lakhotia will
he
appreciate
pulled
this.
his teeth.
Yes, my lord, because of the Amoles Reyes blow, my lord.
Then can you do one thing? Today I'm going back. I'll come back on Tuesday. Monday, my lord.
What is this?
I just said
the issue.
Issue is, my lord. I said, my lord, whether the issue is whether subdivisional land and land user could have
Whether
subdivisional land and land use officer could have held a public auction in respect of shade trees of my tea garden, which was felled pursuant to order of the district magistrate. This is the issue.
Then I will demonstrate, my lord. They have in the garb of my lord,
Right.
shade tree, they have fallen all the, my lord, the mature tree.
Tuesday.
Monday, yes, Tuesday.
Tuesday. You will remain here for the entire week, Mr. Rai, or you will go back?
No, Tuesday I'll come. Monday evening I'll come back. But the division bench, your lordship is there now. Presidency bench, Chief Justice bench.
Yes. No, I'm not on that.
No.
So Tuesday will be coming.
Yes.
You will stay here for the entire week, or you will again go back.
No, I'll stay.
We'll stay for the entire
Doing
week.
hopping, my lord. Forum shopping, my lord, hopping. This is not permissible, my lord. Hopping.
It's you who is permitting Mr. Rai to go back.
Yes.
You cannot hold him here.
All the tickets
Grateful.
which I booked will be cancelled, my lord, tomorrow. Grateful, my lord.
Mr. Ryle, honored senior advocate for the petitioner, commences his argument. First of all, at this stage, the learned additional advocate general prays for an accommodation due to his personal inconvenience.
My lord, grateful, my lord.
Stop. Now, at this stage, the learned additional advocate general who appears through virtual mode expresses his desire to
Address your lordship physically.
address the court by appearing physically. In view thereof, as jointly paid by the learned counsels for the respective parties, list this matter Tuesday date. Yes, next.
Grateful, my lord. Much
Grateful,
obliged.
Lordship.
Yes,
Grateful, Lordship.
I've also not objected.
26.
I am afraid of another teeth, my lord. Another blow.
Yes, yes. Who is appearing?
Lord, I am for the state, led by Learned AGP.
State. Who is for the petitioner?
For short pass over.
Why?
Lordship, Dr. Arjun Chaudhary appearing in this matter, he is on his legs before the division bench, Lordship. Short pass over, Lordship. I'm
Pass
grateful.
over next.
Not today.
14 to 15.
Not today. Next.
That municipal corporation matter.
Yes, Mr. Rai, what did
Your
say
lordship will
after
kindly
2 p.m. or
After 2 p.m.
Lord, your
Mr.
lordship,
Mukherjee, it's convenient time for you.
my lord, yes.
Yesterday you expressed some difficulty at some point of
Your
time.
lordship,
I really have some, but Lord, I'll try to assist your lordship.
Yes, yes.
Lord, I have an order with me which says that the house, Lord, at the time of being built by the previous owner, it is not written residential stroke commercial. This document is not annexed to the writ petition, unfortunately. Lord, I can hand over a copy through Mr. Dash, who is present there in court, which will speak of the fact that, Lord, the property was not for residential commercial use. Now, Lord, your lordship yesterday, Lord, put a very relevant query to us to say that the plan depicts the nature of user. Lord, in the ground floor, Lord, there is a residential use, there is a bedroom, and Lord, there are 2 shop rooms. Now, Lord, in the first and the second floor, Lord, those are Lord the chambers, and it was Lord a doctor's.
First and second floor or only first floor?
No,
First and second. First and
So
second.
three-storied building.
There are 3-storied building.
All right. First and
So,
second
Lord,
floor.
first and second floor, Lord, according to the usage pattern, it is a commercial building.
Yes.
There are chambers written down. There is a hall. That was a hall for the waiting of the patient of the Lord, my vendor doctor. And Lord, so far as Lord, the ground floor is concerned, one of the shop room is occupied by Mr. Rai's client.
Yes.
So Lord, that portion is commercial. Now, Lord, to answer my Lord, on section 272, Lord, if Lord the municipal authority, Lord, I will apply for Lord the conversion of the residential portion, that is Lord 2 rooms in the ground floor. Now, Lord, I will certainly apply within Lord a 7 days period. Now, Lord, so far as to their Lord the query about Lord that I should be stopping my business, Lord, that they cannot do so because Lord they have sanctioned the building Lord as a residential and commercial. And Lord, how much is residential and how much is commercial can only be found out from the sanction plan.
Yes.
So far as Lord the illegal construction is concerned, I pointed out Lord there are 6 points decided by Lord the municipal commission.
Yes.
Now, Lord, of the 6 points, Lord, yesterday my argument was with reference to a notification of Lord 2023.
Yes.
Which says about Lord that there is a permissible Lord regularization in respect of Lord a minor deviation of 5%.
Yes, yes.
Lord, yesterday it was handed over.
Yes,
Lord,
yes, Mr. Mukherjee, I recollect that you handed up. But where is that?
Mr. Das, can you hand over another copy
Yes,
to my
yes,
Lord?
I have.
কোথায় গেল সেটা? দিয়েছিল তো।
There's a copy with me also.
কোথায় গেল? All right, yes.
Now, my lord, one
No,
A, B,
just
C.
now it has been given. I have now got it, but I do not know where my copy has gone. Yes. Yes, Mr. Mukherjee.
Now, my lord, if your lordship kindly comes to my lord, page 111 straight.
Yes.
Now, my lord, there are, my lord, your lordship will find, my lord, there are 6 findings against my client.
Yes. Yes.
First one, my lord, it records that the building is partly commercial, partly residential.
Yes.
But as per physical verification, the ground floor is being used as full commercial purpose. So, my lord, it is only about the ground floor that they are talking about, which speaks in the sanction plan about, my lord, 2 rooms, which is, my lord, earmarked as a bedroom in the
Yes.
ground floor.
Yes.
Now, my lord, number 2, my lord, this concerns, my lord, that construction.
Yes.
2 and, my lord, 3. Your lordship will find I am covered under, my lord, the 2023, my lord, notification, which the authority did not consider.
So that has to be decided on facts by the authority.
Yes, but the authority only said that 223 notification, 2023 notification does not apply.
Yes.
But whether, my lord, they have a sanction plan.
Yes,
They
so
know
they
the
have
area
to
of
decide.
construction.
They have to decide in terms of this notification on facts, whether
Lordship.
it falls within that expression, minor deviation, and if so, to take appropriate steps.
Your lordship's views are
Lordship.
reason, but time place it, reason should be given.
Yes. Yes. Yes, Mr. Mukherjee.
Then, my lord, your lordship will kindly, my lord, come to, my lord,
item number 4.
4. My lord, the 4, my lord, I have, my lord, the weight of the machinery is with me, but I will just tell your lordship, it is blood testing laboratory, pathological laboratory. It is not a manufacturing process that is being carried on. I can take, my lord, the structural stability from, my lord, the manufacturer of these machines.
Yes.
Now, my lord, other thing is no sanction permission was acquired to install such machinery. My lord, I do not find anywhere, my lord, that under the Municipal Act, Corporation Act, West Bengal Municipal Corporation Act, but I need to take a permission when, my lord, I pay trade license. I have, my lord, the pollution control.
So where is that, Mr. Mukherjee? Where is that? They have said that they have to. You have to take permission.
Not the last bracketed portion of paragraph 4. That number 4 finding.
Last bracketed portion. Yes, yes. Any sanction
no
was
sanction
acquired. Yes, yes. Yes, I have got.
Lordship.
Yes.
So, Lord, I have, Lord, all the licenses with me. The trade license has been annexed, produced. The clinical establishment license was not there and produced. Lord, I have the pollution control certificate, which is not produced before there. Lord, I do not find any provision. Mr. Dhod is there to enlighten us about which of the provision that they speak about, not for installation of a machinery in a commercial property, admittedly, which is not bearing from the plan, sanction plan.
Yes.
Now, Lord, this 5 is, Lord, nothing, Lord, that happens because it is an old building. The roof.
So you have to take steps to repair and to make it.
Lord, that I will do. Lord, that I will do. That is for my own. That is for my own, Lord, safety.
For your own benefit, you have to do that, and it also may affect the stability of the building.
Yes. Yes.
May affect the stability of the building. And what is with regard to the fire license?
The fire license is annexed. Mr. Das is there, Lord. He will just point out.
Because
Or rather, Lord, I can point out before your Lord. Kindly have a look at, Lord, page.
So, but you did not. I think you did not produce before the authorities fire license.
No, it was produced. It was produced.
Lord, it was produced.
It was produced.
Lordship.
All right.
So, Lord.
Yes, Mr. Mukherjee.
Then, Lord, kindly come to, Lord, the ordering portion.
Yes.
Lord, just before that, your Lordship will see the paragraph, any construction without a valid building plan sanctioned by the corporation is unauthorized.
Where are you placing, Mr. Mukherjee?
Just
yes,
ordered.
I've got
just before that.
Yes, yes, I've got. Yes.
And under the scheme of the West Bengal Municipal Corporation Act 2006 and Building Rules 2007, and as such needs to be demolished. Then
Yes.
got the ordering portion as per section 287 read with section 266 of the West Bengal Municipal Corporation Act. The opposite party is hereby directed to remove, dismantle the unauthorized structure as pointed out in the inspection report, which are beyond the sanction plan on or before 15/3/2025 at their own cost, failing which the Siliguri Municipal Corporation will remove, dismantle the said unauthorized structure after the expiry of the prescribed period and at the cost will be borne by them. Further, in exercise of powers vested under section 272(4), my client, Serum Analysis Center, is also directed to stop the commercial activities on part of the ground floor, as well as the first floor of the building, since the same has been sanctioned as residential and heavy machineries cannot be permitted to be operated from such premises. Failure to comply with the direction herein above after expiration of the prescribed period will constrain Siliguri Municipal Corporation to remove, dismantle the
You
said
have a copy of
unauthorized
the act.
and the entire cost of demolition. So, beloved, this
Sir,
is not the
Siliguri-
operative
Siliguri
portion.
Municipal Corporation, West Bengal Municipal Corporation Act नहीं नहीं ना लेट पाए देखे नहीं तो ना लेट आनी नहीं
272. My lord is.
Yes, Mr. Mukherjee.
Now, my argument before your lordship, lord, so far as the first floor is concerned, lord, it is a commercial, lord, sanction. So,
Yes.
lord, they cannot prohibit use of, lord, the first floor, lord, in the manner my client is using it. So far as the ground floor part of it, I understand, lord, that they have a, lord, a reason to say.
Yes, Mr. Dhor, what is the basis of your finding that
Your-
this
your-
first floor is
At the time of inspection, they were asked to produce the building plan.
Mr. Can you allow me?
and the deed by which they have purchased. The other, for lordship takes up the deed. Lordship
I just, your lordship, can you allow me to please, I just, your lordship, Mr. Wai, kindly come to S52 for a moment.
52.
Yes. Boss here. Boss, people, boss.
Yes, 52.
This is the building plan.
Yes.
And you see the ground floor, the two shops, 2 bedrooms. You got it, man?
Yes, one bedroom and one drawing come dining.
No. First floor, ground floor,
Ground floor is extreme
ground
left.
floor is on the
Extreme
extreme
left.
left.
Here, extreme left.
There are 2 shop rooms,
Are 2 bedrooms.
1 bedroom, and this is, I think, drawing.
No, bedroom.
This is also bedroom.
Bedrooms are drawings.
Drawing.
That's what the plan.
Drawing come dining.
Yes,
So it's residential.
Yeah. So 1 bedroom, 1 drawings, 2 shops. Now you also kindly come to first floor.
First floor is entirely commercial.
No, well, I show that chamber is not the commercial. I place it.
Chamber is not the commercial.
I brought.
You are keeping in
Yeah,
mind.
I don't have a chamber in
Lawyer's
the-
chamber, Mr. Rai.
Yes.
Are you fighting for a lawyer? Client.
No. I'm just placing.
Mr. Mukherjee is against a lawyer client.
I know it.
He says,
sometimes
Mr.
sometimes we're the same thing. Sometimes
We all are beneficiary of that provision.
Yes.
Yes.
Well, you can see the 3 chambers. Can you
Yes,
see?
3 chambers.
1 hall, 1 office.
Yes.
Yes, ma'am. Same thing when in the third floor. Yes.
Where is the second floor? Second floor plan is not
This,
here.
the first and second floor is
First and
same.
second
That
floor.
is
First
written
and
down
second
in the
floor.
below. In
The
the
first and
Second
yes,
and fourth
not very
existing first
legible.
and second floor.
My lord,
Oh, that is same.
yes,
Same.
So my lord, 3 chambers, please.
So
Achha.
propose, that means now, yes.
So 3 chambers, 1 hall, 1 office. The issue is whether it is a residential house or whether it can be used as a commercial or not. This is the issue. Mr. Mohaji's argument that it is a commercial building.
No, I have an order. I have not produced that, Mr. Rai. I'm very sorry about that. I have an order, Mr. Rajat Das is there. He can print out.
Which one?
This ought to have been annexed with the writ petition. I have an
What
order.
does it say, Mr. Mukherjee? What does it say? What does it say?
It says, reference your application dated 3/5/90 for grant of permission of construction of a 3-story residential stroke commercial
Yes,
building.
commercial is there, shops are there.
Even that
Ground floor shops are
Siliguri
there.
Municipal Corporation says that it is a commercial.
I'm not disputing. Ground floor, there are two shops. I can see. It's a doctor's house. He was a vendor, he was a doctor in Siliguri. Who sold it? So doctors having two shops on ground floor, bedroom and drawing, and upper two, 3 chambers, 1 hall, 1 office room. Man, can you see when doctors sold this property to a landlord client, can you come to pay the deed?
He is also a doctor.
Who?
Mr. Mukherjee's client? No.
No.
No, we run a pathological laboratory from there.
But you are not a doctor.
No.
But I do not know whether the
No,
director
he's
is
a
a
doctor.
doctor or not.
Well, page 69, can you come? This is a deed.
No, Mr. Rai, only one thing.
I'm coming. I test my use. Can you, in my page
Yes.
69?
Yes.
Page 69 is the deed. It starts with, this is a deed of sale. Mr.
Yes.
Mukherjee's client purchase it.
Yes.
Kindly come to page 90 of declaration.
Page 90.
90. Deed
Yes.
starts from 69. Can you get 90?
Yes, 90.
When they have purchased it, they have to get the declaration, ground floor. Semi-commercial user, commercial.
No,
floor.
what is this? This
This
is
is
the
a part-
query.
It's a part of the deed of sale, madam. When you purchase land details, it's a part of the deed, madam. They have given.
No, that is the.
This is not part of the deed. I think this is part of the query.
Yes, I think
Query.
this is the part of the query.
Query is
part of the
on the basis of that you have purchased the deed.
No, that doesn't mean
Query
anything. The
is,
query
Mr.
doesn't
Rai,
mean anything.
for the
For
purpose
the
of ascertaining the
valuation of the.
valuation and the stamp duty and
Yes.
the,
So
Yes,
give a
yes.
declaration. Can you see?
yes,
First floor, residential use, mosaic floor, second floor, residential use. So when he sold it, has given the declaration for the residential purpose. Now I will come to the chamber. So now who's the chamber? Who's the chamber is a commercial or non-commercial?
so according to you, as per this declaration, it's residential.
They said, and this is
Yes,
they-
as
they-
per their declaration, it's
now I'm coming to a
residential.
point of law. The law can come to, I just listen. Black edition. And can you see? Right, sorry, I have done group. Which, and this, I have to do it.
Yes,
Can I say black is a, what is a profession? A vocation requiring.
profession. No,
Yeah.
definition of profession.
Yes, a vocation required advanced education and training, etc. One of the 3 traditional learned professions: law, medicine, and the ministry. So, what is the difference of profession and the commercial activity? I'm coming, my lord. Now you are secondly.
No, Mr. Rai, I follow your argument. Only one thing.
Sir, use.
It's an adjudication on facts. There has to be an adjudication on facts, whether it's because it's not in dispute, a portion is residential, portion is commercial, as per that plan.
Ground
Now-
floor is a commercial.
Yes. So let us not divide that ground floor and first floor. So a portion of the building is residential, portion is commercial. So that adjudication on facts has to be made. It's the municipality who can, on the basis of the documents, because the municipality is the custodian of the records.
These are for first.
So
And I
when they
understand.
applied for the sanction plan, they have to specify what will be the mode of use. On that ground,
Yes.
this sanction
Chamber is, my lord.
so
It's not the
sanction is to be
commercial.
granted. Yes, let them decide that this was,
This was for, yes, I understand.
so if
So-
that is, so the municipality has
Yeah.
come to
There's
a
an
finding.
office also. There's an
Yes.
office on the
Yes,
first
yes,
floor.
also,
whether
there
it
is
is-
office, yes, Mr.
Yes, whether it's, I think what is the mode of use there, residential and non-residential or commercial also?
No, my lord,
This
no,
section
no.
says about the mode of use.
These are the building rules. Earlier, there's no such, now.
No, there is a, I think
Not
there is a
that, not in
categorization.
the act.
Not in the act rules. Show me the rules.
The rules, my lord, this is inserted subsequently.
But it was
But
sanctioned
section
when not
2A.
the West Bengal Municipal Act was in force. Now the
Yes.
Municipal Corporation
No,
Act has come.
rules is there, rules is, Mr. Mukherjee, rules is there. So section 2A, it has come subsequent.
Rule,
Section 2, capital A.
section 2,
No, rule 2, rule 2A.
Rule
sorry.
2A.
I'm always cured of this one. Rule 2A.
Rule 2A, yes,
So it is
classification.
It has subsequently inserted. my lord.
It is subsequent, Calcutta 1990.
I know.
1990, this was sanctioned in 1990
Yes,
under the
it is sub-
previous act.
Where is the earlier rule?
In the earlier rules, there is no classification of buildings.
This is the
No, no, it has
residential
to be.
commercial.
Classification of user is there.
User is there, but
Whether
it
it's
is considered not-
residential is one of the use,
Yes. I
whether
understand.
the other is non-residential or commercial is also one of the, that
Yes.
is to be looked into.
99
Because the
rules.
nature of user is not all through there
Yes,
in the
yes,
municipal law.
Mr. Rai, let the municipality
No.
decide all these issues.
This is
because
change of user. Now I'm
that is change of user.
now I'm come to the regarding my lord notification. I show my lord that that unauthorized construction that I also
Yes, unauthorized
I
construction.
just specify.
Come to that.
My lord, can you see the first? Mr. They are given the notification.
Yes. You have a copy of the notification. Yes.
Yes. You logically, I come the notification.
Yes.
Then para 1.
Yes.
Scope of minor authorized erection or execution of any minor work without sanction. Internal deviation in form of deviation from sanction line near dimension on part of the building up to the change of internal arrangement. Next, change of sanction covered area of building with variation up to 5 without addition. So there is a change of 5% without addition of any new component. So my lord, if there's a 5% deviation in the outer without addition, now you also can see except prima facie can come
Mr. Rai, let the municipality, because they have
My lord,
not decided on this.
You also can see there's a, if it is on materials, this is a judgment of that aim watches my lord.
Mr. Rai, let the municipality has to decide on this. These are factual aspects. 5%, whether it's 4%
No,
or 6%.
Your logic says that they have to give the reason.
Yes.
Because that aim watches, if the materials are there. If the materials is not.
Factual. This factual part, there's a percentage,
But-
Mr. Rai. There's a percentage.
No, under the percentage.
Yes.
Addition, sorry, man.
Yes, addition, yes.
They said
Yes, addition I have seen.
without
The
addition.
addition must be then
Here the
5%
addition is there.
variation.
No, without addition. Rule says without. Can you
Where is that?
Change of sanctioned cover area with variation up to 5%
My lord, this is without addition.
Yes.
of any
if
new
with
component.
addition, then it will not come into picture. It will not be
Yes.
operation. Now can you see the inspection report itself?
Where is that?
Here also can you come to page 111? I just placed.
111.
Yes. Page up to
Yes.
as near side of 2 numbers of low roof RCC structure exists measuring 3 to 40 millimeters and say low roof RCC structure measuring 3 to 40 meters.
Semi-pakka structure.
Semi-pakka structure.
Yes, this is an addition according to you.
Yes.
Yes, Mr. Rai, I'm not only thing. Part may be regularized, part may be demolished. Part may be regularized. It's not that the entire thing can be regularized. A portion may be regularized, portion may be demolished.
Mr. Mukherjee is relying on the circular. The circular, my lord, says that without any addition.
Yes. They will, they will decide. It may be, a portion may be regularized, balance may be directed to be demolished. If it is within the portion.
They have to say that this addition is not addition.
Yes, that is not there. They have given a blanket that it cannot be.
They have recorded the order of the inspection report. So Lashi knows that how the order was written and passed.
Mr. Dhar has not instructed the person who has passed the order properly.
That I said.
Or they have not taken his opinion prior to the drafting of the order.
So clarify it.
At times, Lord, they request the lawyer to draft the orders, Lord.
You also know very well. Yeah, this is our experience.
We all know, but
No.
we all
Yes,
know.
yes, Mr. Dhar.
So that you take up the building plan, but as a page
52.
52.
Yes,
Now, yesterday, your lordship directed me to take instructions. So I have talked to the engineer.
for what?
So what does this chamber, office and hall, what does it signify?
Yes.
The chamber he said that the chamber means personal room. Chamber has been personal room.
So according to you, it's residential. Chamber is residential.
No, not residential, not commercial. This is a Supreme Court.
Not commercial.
Yeah, our chamber is for the.
Mr. Rai, the chamber of a lawyer is a study room.
Yes, yes.
You say it be a study room and library.
A library, we always say it is a library.
That is the catchword. You have to say it as a library.
Yes,
You use it as a library, then it's out of that. Otherwise,
Supreme Court says, can see. And not your lordship. I was. Sorry, 87.
yes.
No, not this. This is that.
Which?
No, sorry. 81. This one.
This is Mukta Keshi.
No. That.
Mr. Mukherjee will say it has
Yes.
been
No, I'm not this.
overruled.
I'm not this. Paragraph 15. Paragraph 15.
Which? 84
But
for
don't tell office to be a
Yes,
residential
84
thing.
commercial establishment.
Paragraph 15.
Office of a lawyer.
No, I'm not.
Mr. Rai, don't go into this.
No.
Let us-
Paragraph 15.
15.
Yes, not for
Yes.
this. London Singham of the Division of Kerala High Court and dealt with the question as in the appeal. They agree with the reasoning and hold that office of a lawyer of a firm of lawyers, not a commercial establishment within the meaning of section 2. Why my lord, reason isn't given section paragraph 9.
Within the meaning of that particular section.
Yes, of that act.
That act.
Of that act.
Of that act.
Now that says that sale for the sale practice. This is what it is.
Chamber, what he has instructed, the chamber is for the personal use. Beyond that staircase, there is a hall. Hall is residential, dining hall. And by the right side is office. Office can be used for commercial purposes.
No,
So,
all
yeah,
means dining hall
Mr.
is
Thought,
first floor.
these instructions are to be on the basis of some records.
Yes, that.
So you have the records, you decide that issue.
Yes, so what was the reason for writing that they don't have the permission? According to the corporation, they have to restrict their business within this office space. Since the entire first floor has been used for their business, that way.
So, Mr. Dhot, there are two things. One is, let us accept your submission that a major part of first floor is residential. Let us accept for the present. And Mr. Mukherjee's client is using it for commercial. So there is a provision for change of user.
Yes.
So they have to apply for that. If it is residential, where is that provision for change of user?
That is 272 itself.
272.
Of the act.
Which subsection says about this change of?
See,
Lot of
this
A, 1A,
penalty.
1A, 272, 1A.
yes,
Yes.
one.
If no person shall without the written permission or otherwise than
Change the-
if any of such
Got
permission use or permit to be used, any part of not originally erected or authorized to be used for such purpose.
And second,
This
kindly also
authorizes-
see B. They kindly also see B.
Convert
1B.
or allow the conversion of a tenement under a particular occupancy under another. So they can apply without permission is a violation. So they can apply for change of this.
That day, this is
And
regarding
also
demo.
required that whether this why this notification will be applicable. They said that there is a addition of new component. So
That I say.
Make
That
that
has to be
clear in the order.
Yes.
Make that clear in the order.
That what is a component of a building? That is
Yes.
not
Yes,
what
yes.
do they understand by
That-
component of a building?
The petitioner herein is the owner, petitioner or petitioners?
Petitioner. Petitioner.
The petitioner
Company.
herein is the owner of, where is the building, is the owner of premises number 47 by A by 1 by 217. What is the municipal holding number?
Yes, 147 by 1 by.
Is the owner of a three-storied building.
3-story.
Is the owner of G plus
Three-story.
two-storied G
Yes.
plus two-storied building.
It's not G plus, it's a direct 3 plus.
And it's G plus three-story, two-storied one is 3 tala.
Acha,
G
is the owner of a three-storied kore dao. Is the owner of a three-storied building bearing municipal holding number 147/A, capital A/1 by 217. There is no road name or nothing.
Yes, SF road. SF road.
Where is
SF
that?
road.
You have not mentioned that in paragraph 8. Where have you mentioned the particulars? 7. Where is the holding number? It has not been said. Any road name? Nothing.
In the plan, it is written SF road. I do not know what
Where
is
is
the full
SF
form of
road?
Station feeder road.
station
But
feeder
here you
road.
have not mentioned anywhere in the paragraph. কি বললাম? ওই নাম্বারের পরে লিখুন SF road বলছেন। S full stop F. Please check that. SF road
The plan says SF road.
within ward number 26 of the Siliguri Municipal Corporation. Full stop. The private respondent herein is a tenant.
Is a tenant.
Tenant.
It's
Is
my
a
tenant.
So this is occupant. Thank you.
Tenant.
Is
Tenant.
a tenant in respect of one room,
Shop
one
room.
shop room situated at the ground floor of the said premises. Full stop. Paragraph. The private respondent herein lodged a complaint with the municipal authority alleging that the petitioner has made unauthorized construction in a portion of the said premises. Full stop. Previously, any writ petition was filed.
Yes, there was a previous writ petition with an order, my lord, that
Where is the order page?
that your lordship will find at page, my lord, 57. Page 57.
Alleging inaction on the unauthorized construction in a portion of the said premises. Just a paragraph. Alleging inaction, that was alleging inaction.
My lord.
Alleging inaction on the part of the municipal authority, the private respondent filed a writ petition being WPA 1011 of 2024, which was disposed of by a coordinate bench by an order dated June 19, 2024, by directing the municipal authority to conduct an inspection, and after serving copy of the report of the inspection to the respective parties, to conduct a hearing and to pass a reasoned order within the time limit indicated in the said order. First up. Pursuant to the said order, the Commissioner, Siliguri Municipal Corporation, passed an order dated February 18, 2025. First up. In the first portion of the said order, the petitioner, by the first portion of the said order, the petitioner herein was directed to remove/dismantle the unauthorized structures as pointed out in the inspection report which are beyond the sanction plan within the time limit mentioned in the said order, failing which the corporation will remove/dismantle the said unauthorized structure after expiry of the prescribed period, and the cost shall be borne by the petitioner. Full stop. In the later part of the said order, by the later part of the said order, the petitioner was directed to stop the commercial activities on the part of the ground floor as well as the first floor of the building, since the same has been sanctioned as residential and heavy machineries cannot be permitted to be operated from such premises. Full stop. Paragraph. The order of the commissioner dated February 18, 2025 is under challenge at the instance of the owner of the said premises. Full stop. Paragraph. Mr. Mukherjee, learned senior advocate representing the petitioners, submits that the Government of West Bengal Urban Development and Municipal Affairs Department, within bracket Municipal Affairs branch, issued a notification dated December 4, 2023, the manner notification wherein the guidelines were framed for deciding the minor unauthorized erection and for regularization of such minor unauthorized construction. He submits that the municipal authority, without taking into consideration this notification dated December 4, 2023, without considering the effect of the notification in its true letter and spirit, held that the deviations cannot be regularized, taking aid of such notification. Mr. Mukherjee further submits that the premises that the building plan of the said premises was sanctioned as part residential and part commercial.
Yes.
And such aspect of the matter was also not taken note of by the commissioner while passing the impugned order. Paragraph. Mr. Ryle, on its senior advocate representing the private respondent, seriously disputes the submission of Mr. Mukherjee. he submits that the nature of violation as indicated in the inspection report does not fall within the scope of minor unauthorized erection, double inverted comma, within the scope of minor unauthorized erection or double inverted comma, execution of any minor work without sanction, double inverted comma, as specified under various clauses
Small
of
clause B, and only on the small clause B.
under various clauses of paragraph 1 of the said notification. First up, now, by drawing the attention of the court to the sanctioned building plan of the said property, of the said premises, Mr. Rai contended that the ground floor is partly commercial. The ground floor was contended that the mode of user as per the sanction plan in respect of the ground floor was partly residential and partly commercial, and the first floor and second floor are entirely residential, are for entirely residential purpose.
Actually, no, the 3 chambers, there is other office rooms also there.
What is your submission?
My submission is that the chambers and halls, those are residential office.
So that is also partly residential, partly commercial. Acha, কি হলো? ওটা বলো, ওটা কি? গ্রাউন্ড ফ্লোরটা হয়ে গেল, ফার্স্ট ফ্লোরটা কি বললো? ফার্স্ট এন্ড সেকেন্ড ফ্লোর?
Same thing.
না, are also partly residential and partly commercial. He submits that since the petitioner herein is using the entire property excepting the portion occupied by the private respondent for commercial purpose, which was sanctioned, the mode of user of such portions being for residential purpose, comma, the municipal authority was justified in directing the petitioner to stop
Commercial use.
the commercial activities on the portion of the ground floor as well as the first floor of the building. No direction with regard to the second floor.
Only commercial.
Second floor is entirely commercial because direction is not with regard to second floor anything. Please check up that. Mr. Paragraph.
First floor, ground and first floor only.
Ground and first.
Second
Full stop.
floor,
Paragraph. Mr. Dhol, learned advocate appearing for the Siliguri Municipal Corporation, submits on instructions from the concerned engineer that the first floor was sanctioned as partly residential and partly commercial. Paragraph. Heard the learned advocates for the parties and peruse the materials placed. After going through the order impugned, this court finds that the inspection report, that the observations of the inspecting team as recorded in the inspection report has been extracted in the said order. after going through point numbers 2 and 3 of the inspection report as extracted in the impugned order, this court finds that the same relates to unauthorized construction no floor has been mentioned, rooftop. This is item number 2 is where? Yes, yes, in which floor? আচ্ছা ছেড়ে দিন item number 2 and 3 কি বললাম? Relates to unauthorized construction. First up. The notification dated December 4, 2023 states that that's in exercise of the powers conferred by second proviso to sub-rule 2 of Rule 32 of the West Bengal Municipal within bracket building bracket close rules 2007, the governor for the purpose of determining minor unauthorized erection, or execution of any minor work without sanction, and the rates for regularizing such minor unauthorized erection, or execution of any minor work without sanction, is pleased hereby to specify that any unauthorized erection or work may be determined by the Board of Councillors as minor inverted comma, keeping regard to the conditions noted in paragraph 1, and such minor unauthorized erection, or execution of any minor work without sanction may be regularized by the Board of Councillors on payment of such fees as described in paragraph 2 of the said notification. Upon going to the said notification, this court finds that a provision for determination of the minor unauthorized erection or execution of any minor work without sanction has been specified, and a provision for regularization of the same has also been made by the said notification. As to the scope of minor unauthorized erection or execution of any minor work without sanction, it would be relevant to take note of clause A, B, small a, small b, and small c of paragraph 1. Full stop. Thus, the competent authority, while arriving at a finding as to whether the impugned erection falls within the scope of minor unauthorized erection, or execution of any minor work without sanction, a factual finding in that regard by the municipal authority is necessary, is required. Full stop. However, in the case on hand, the municipal authority, without applying the procedures laid down under paragraph 1 of the said of the notification dated December 4, 2023.
May I just interrupt? I
Yes.
also applied to the municipal authority to consider the construction under this notification. That they have recorded in the order also.
No, I could not follow Mr. Mukherjee.
But I have also applied for regularization of the construction following the notification.
All
That
right,
they have not done, and that they have recorded in the order itself.
all right, কি হলো? কি বললাম? আচ্ছা, তার আগে লিখুন এটা কেটে দিয়ে Mr. Mukherjee would contend that the petitioner applied before the municipal authority for regularization of the minor unauthorized erection in terms of the notification dated December 4, 2023. However, this court finds that the municipal authority, without considering without applying the procedures laid down under paragraph 1 of the notification dated December 4, 2023, observed that the deviations that have been detected in the inspection report cannot be regularized, taking aid of the notification dated December 4, 2023, issued by the state government. The reasons as to why the same cannot be regularized has not been specified in details. First up, whether the entire unauthorized construction, whether a portion of the unauthorized construction, whether the entire unauthorized construction or a portion thereof falls within the scope of minor unauthorized erection or erection of any minor work without sanction has to be specifically considered and determined by the concerned authority in terms of paragraphs small a, b, c of paragraph 1 of the notification dated December 4, 2023. Since such an exercise has not been undertaken by the municipal authority, this court is inclined to interfere with the portion of the order directing demolition of the removal or dismantling the unauthorized structures as pointed out in the inspection report. Now, this court has to consider the other portion of the order whereby the petitioner was directed to stop commercial activities on a portion of the said premises. Mr. Mukherjee would contend that the mode of user as per the sanction plan was partly residential and partly commercial without any identification as to which portion of each floor would be residential or commercial. Full stop. Paragraph. Mr. Rai would contend that the portions which were Mr. Rai would contend that the mode of user as per the sanction. Mr. Rai would contend that the petitioner has violated the mode of user of the premises as per the sanction plan. Full stop. Paragraph. This court finds that the municipal authority directed the petitioner, it is not in dispute that portions of ground floor and first floor was sanctioned for commercial purpose. Full stop. The portions which were sanctioned as residential in the ground floor as well as the first floor, but is being used as for commercial purpose has not been specifically stated in the said order. Full stop. At this stage, Mr. Mukherjee, learned advocate appearing for the petitioner, would contend that Section 272 of the West Bengal Municipal Corporation Act 2006 gives a right to the owner to apply for permission for using any part of the building for a purpose that was not originally erected or authorized to be used as such. Full stop. However, it is not in dispute that no permission to such effect has been sought for by the petitioner. Full stop. At this stage, Mr. Mukherjee would submit that liberty be given to the petitioner to apply before the municipal authority for change or / conversion of the mode of user of any portion of the property. Full stop. Paragraph. Yes, Mr. Dhor, what do you submit with regard to this heavy machineries? What permission is necessary? Under what provision of the Act?
Engineer who went for inspection, he found those.
Under what provision?
Produce any license under the clinical establishment.
That is a different thing. That is a different thing, but you have said heavy machineries cannot be. On a query of the court, Mr. Dhol, learned advocate appearing for the municipal corporation, could not point out any provision from the West Bengal Municipal Corporation Act 2006 or the rules framed thereunder, which lays down, which provides for permission to be taken for installation of machineries in a building. Full stop. Paragraph. However, Mr. Dhos submits that at the time of inspection, the petitioner could not produce the permission under the permission or license under the permission / license under the Clinical Establishments Act. Mr. Mukherjee would submit that they are possessing all the certificates for running a pathological center at the said premises, including the fire certificate, fire safety certificate, fire safety certificate, and the license under the Clinical Establishment Act. Full stop. Thus, the finding of the Commissioner Shiliguri Municipal Corporation that the petitioner has not. Where is that, Mr. Mukherjee? You said that no permission, that no sanction or permission was acquired for installation of the machinery is without any basis. Full stop.
Why this was written? Because in the entire first floor, this machineries were there. So this machineries were there in the residential part. Also.
That is a different thing. You said heavy sanction. Where is the sanction required?
Stability is different.
Full stop. Paragraph. Mr. Mukherjee, you have to produce the structural stability certificate.
But I undertake to produce that.
Uh,
I undertake.
However, it appears from the inspection report that the installation of heavy machineries in the first floor of the premises is likely to affect the structural stability of the building. First of Mr. Mukherjee, upon instructions from the learned advocate on record, undertakes to submit the structural stability certificate from a competent person before the municipality. Full stop.
From
At the time
impaneled
of
structural engineer.
Time of hearing.
From an impaneled structural engineer.
From an impaneled structural engineer of the municipality.
Yes, not impaneled with the municipality. Not all municipality
All
have
right.
impaneled.
With the municipality, from an impaneled structural stability engineer of the municipality. Yes. First up, at the time of hearing, first up, paragraph, the petitioner also undertakes to repair the roof slab of the
Look, this
ground.
is the first floor. Because the stage is in the ground floor.
This part will not touch it because after hearing that will be done. Because there's some demolition, maybe.
All right.
No,
Yes.
roof slab of the ground floor.
I
That is
follow you,
the
Mr.
floor of
Mayor.
the first floor.
Yes. No, fresh hearing is to be made. So at that point of
Then you
time,
can
you can
take
do
this
that.
Very,
But
very
now
good.
Paragraph. So I think the structural stability also that can be done at that stage. Otherwise, it may be difficult.
Yes.
But structural stability is with reference to not the machineries that they allege.
Yes, but
others are not.
Demolition
That
all
is a
right, let me
partly
produce
pakka
because
structure
yes.
according to them.
At the time hearing.
For
Partly
the
pakka.
reasons as aforesaid, the order dated February 18, 2025, for all the reasons as aforesaid, the order dated February 18, 2025 is set aside. Full stop. The Commissioner Siliguri Municipal Corporation is directed to conduct
To revisit the issue.
to revisit the issue.
Two issues.
To revisit the aforesaid issues afresh after giving opportunity of hearing to the respective parties and by passing a rescinded order. First of needless to mention that the rescinded order shall be communicated to the parties immediately thereafter. So the entire exercise shall be completed within a period of all right. Within a period of 8 weeks from the date of receipt of a server copy of this order. Mr. Mukherjee, server copy along with your application paying for change of user.
But that is
Liberty.
Liberty.
Yes, but I will do that. I'll do
Given
that.
my lord.
I'll do that. I'll do
Acha,
that.
This is his liberty.
server copy of this order. With the above observations and directions, the writ petition stands.
I'm going to airport.
Yes. With the above observations and directions, the writ petition stands allowed.
I'm grateful, Miller.
Grateful. Eta একটু রেখে দেবেন, এটা লাগবে কিন্তু. Yes, Mr. Raj, take back his. Where is Mr. Raj? Yes, gone. Both the books have been supplied by him. Take back. Yes. Call the next matter.
Grateful.
Thank you, Mr. Mukherjee.
I'm grateful, madam.
Yes.
Lordship. In 29, I am for the petitioner, your Lordship. This is the matter of revised PPO.
Revised
The date of-
PPO.
Yes, Lordship. From the lead petitioner is entitled for retirement benefit from the date of joining, your Lordship. So yesterday.
Yes, what is your
date
instruction?
For
On behalf of the estate, Lordship, kindly see.
What?
Instruction, Lordship.
What is your instruction?
Lordship, it is admitted that the petitioner is joined in the year 1978, Lordship.
Yes.
But Lordship, the PPO has been revised. PPO is the revised last basic pay of rupees 16,390.
Has been provided with effect from the date of our joining.
no,
Yes,
Lordship.
It is his instruction. Kindly see this.
No, Lordship. I annex the two PPOs, original PPO and revised RUPA 19 PPOs, or both are
Lordship,
annexed.
paragraph number 8, Lordship. 7, Lordship.
Yes. Please see this. Their instruction. Do you have another copy?
Yes, sir.
Give it to him. Come tomorrow.
Yes, Lordship. Can I come
Please,
tomorrow?
please give him a copy of
copy.
that. Ashwin, the written instructions filed by the learned advocate for the state is taken on record. The learned advocate for the petitioner prays for an accommodation to consider the same. To stop Monday?
Lordship.
Yes. Next.
No. No,
Yes,
no
call the
other
next matter.
instruction. Lordship, next matter. 30. Lordship, this petitioner also
Same.
entitled. No, Lordship, these are 81. 81, right? That is the same is Subrashom, their memo and others
Yes,
the
yes.
same. What is their instruction?
You are the effective respondent. Yes.
Their instruction.
Means I have a report from the PI inspector.
What is your report? Same thing. From day of joining. Please see this. Same order. Come on Monday. Yes, next.
Lordship, Monday. Copy down.
When your grievance is redressed,
So, Lordship,
they are saying it is done. Yes,
Lordship,
call the
sign-
next matter.
Pilot not today.
Not today, not today. Yes, next. Not today, next.
Lordship, item number 33.
Yes. Yes, Mr. Saraf. Where is Mr. Saraf?
Saraf is there, Lordship.
Well, is it 33?
Yes.
My learned junior, my lord, Mr. Miss Sarkar is there, my lord.
Yes, yes.
Uh,
Mr. Saraf is not here. Not today, next.
petitioner is not here, my lord.
Yes.
No.
Oh, my
Yes.
lord.
Call the next matter. 33 হয়ে গেল তো, next.
The analogous matter, Lordship, from 34 to 38.
I have intervened in this matter.
Let Mr. Badi appear on this matter
intervened in
first,
this
then I will be
matter,
appearing, my lord.
Mr. Bari will appear first. Why?
My lord.
Mr. Bari, which matter is yours? 35 টা দিন। এটা কত? 34? হ্যাঁ, 35 টা দিন। 35 টা।
But in this matter, my lord,
It's a
yesterday I have
very
made submission.
heavily contested matter at 4.
And before, before Mr. Bari begins, my lord,
Your lordship's desire was to be present. That's why leaving aside all of my, I had to.
Why?
It practically, my lord, yesterday the matter was taken for consideration. Some judgments are required to be.
Mr. Bari, if this issue is pending.
No, that is the entire, that's the wrong.
That is Mr. Ahmed
Let
saying
Mr.
that.
Ahmed will say everything with a political consideration will also be. Let them say so, but these.
No, if, because in order to avoid this conflict, let this be tagged along.
That exactly that point was taken by the coordinate bench. Not only once, it is 4, 5, 6, 7, 8, 9, 10 times. Even before the division. To show it enough. Mr. Samet's client there, although.
What is the issue?
I tell you. My lord, here, the School Service Commission Act has been suspended from the date of introduction, except one. One selection process was held in the year of 1998 or 1999. Thereafter, for agitations of the political considerations, entire School Service Commission Act or the procedure has been suspended. Then, what is the alternative way? The school had to close down due to non-availability of the teachers, or entire, the hill area will be the same problem.
So earlier procedure according to you.
Earlier procedure is required to be. To show earlier procedure, that is not the mandatory provision as our special bench has said so. The guideline, that is the, your lordship knows that the guideline issued by the director of school education, that our court special bench, 5 judges bench has said, this is not a mandatory provision. In violation of that guideline, if anybody is appointed, that cannot be said it is illegal. To show one of the school authority appointed us following the internal arrangement, selecting this, holding interview against the sanctioned faculty. Because the teachers were or non-teaching staffs were retiring.
Who are you?
I am the some of the teachers, some of the non-teaching staffs.
Teachers as well as non-teaching.
Yeah.
Now, what has happened? What is the procedure followed?
It is for the managing committee who hold an interview and appointed against the regular vacant post.
Yes, School Service Commission is not a party.
No, because they have got no. To show, my lord, the question is, they came up before this court considerations. If they against the vacant post, if anybody is appointed, and my lord, what will happen? Question of regulations. Then it was hotly contested. Ultimately, a single judge was pleased to allow, because the certain section of the employee has been given benefit by virtue of the court order others. Then the court passed an order directing them to approve the appointment against which they are prisoners of working in the sanctioned post. Now an appeal was taken up. The appeal court dismissed the appeal filed by the GTA and confirmed the order of the learned single judge. After the appeal court order, several orders of the coordinate bench was passed, and before that it was passed. The plea was taken by the GTA, also the other authorities. The similar issue is pending before the Calcutta High Court principal bench. To show matter can be adjourned, let us wait for some time. The results comes out thereafter. But that prayer was done down by the each and every coordinate bench. That judgment. To show matter at this point,
what is the issue pending before the division bench?
They have given the 313 persons appointed, 313 persons who were appointed. A challenge was thrown by an.
They were appointed how? They were appointed how?
They are appointed, my lord, that we are not party, we will not be able to assist your lordships, that read petitions, what has happened. But that is not the issue.
well, I'll be assisting your lordship on that.
Yeah, who is he? Has he filed an application for addition of party? Your lordships will allow everybody. They may come, they may interfere, they may say who is how they are agreed. A person is coming before the what is the legal right to interview.
I'll explain.
It is not a public interest litigations.
I'll explain.
To show, my lord, if your lordships can permit me, I can place all the judgments, including the judgment of the revision bench. This is the main issue. Now, the single bench, I do not know who they got the appointments, what is their issue, what is there going on. this, my humble submission before lordships, kindly do not mix up this issue along with this. They filed the writ petitions for termination of the service. We filed the writ petitions praying for approval of our service. To show completely different things. To show it should not be referred back or it should
So
not be
you prayed
adjourned.
for approval.
Approval.
So, what is the stand of the state? No,
Man,
they are
after the division bench judgment, nothing.
Lordship,
After the
I
division
contended
bench judgment, they have accepted.
that without the recommendation of the, because the state has filed, published a notification where it.
you are for GTA.
Yes, Lordship.
Yes.
Where it is stated that the without the
Approval
recommendation.
will be by the GTA.
Yes. But
Understood.
initially, the state has issued a notification where it is stated that the without the recommendation of the state government, GTA has no authority to regularize their service. So there is
But
a,
GTA has regularized their
but
service.
subsequent,
So in this matter,
yes,
what happened? GTA has regularized their service.
no Lordship.
Has
That's
not
why they
regularized.
have
No,
filed
no,
this writ petition.
we are paying for regularization.
So directing the GTA to regularize.
Yes.
In terms of.
Yes, what is your stand?
Lordship, because we have filed the appeal before the division bench and division bench,
Oh, you have filed an appeal
Yes,
for the division. bench.
because the state obstruct us giving their appointment because that notification which says that without the recommendation of the state government.
Where is that notification?
Lordship, that they are not.
Now, your lordships kindly have a look to this writ petition
Okay.
of 35.
35, yes, 677.
6 minutes.
Yes.
Acha, acha, ওটা দিয়েছি।
19 থেকে 21 অব্দি আছে আমার।
Yes.
এটাই।
Your lordships kindly see. The page 21. These are the appointment of the non-teaching.
No, where is the notification which?
No, notification of page 24, 22. 22. The
This
said,
says
the commissioner
secretary.
said with reference to the
appointment
directed
with
to
the
request
person.
him kindly refer to the order issued by the education department which does not appear to have been issued with the concurrence of the department. Since no reference of the department memo instruction is mentioned here, hence the undersigned is further directed to inform the DI that may advise not to proceed with the appointment. This was challenged
Let him.
earlier repetition and this was taken into consideration in all judgments.
Page 21.
আমাকে দেখতে দিতে। Selected 20.
Yes.
Stand down.
Your lordships got it.
Yes, page 22.
Twenty-two.
আমাকে 21 আমাকে 20।
This is the
But,
administrative instruction.
Mr. Pari, page 23,
Yes.
it refers to an order of the division bench.
Yes,
Where is that?
they have given, well, that division bench judgment, your lordships kindly have a look to this. It must have been.
970।
কত নম্বর আছে?
আমারটা আছে 29 আমারটা মনে হয় 29
সিঙ্গেল বেঞ্চ
এই যে নিচে
ওটা আমার হাতে আছে এটা check করতে হবে।
So Bari, what is the effect of the division bench judgment?
My lord, the-
Paragraph 17
yes,
says that the managing committee of each aided school,
yes.
who will give the aid?
No matter these are.
Who
the-
will give the aid?
I tell you, lordships. In
State
GTA Act, in GTA Act, section 26, it has been provided the educations, others, it has been bifurcated, it has been given to the GTA. Section 26, if your lordships kindly.
Yes,
Have a look.
so the GTA will give the aid,
Yes.
not by the government.
No, GTA and government between their internal fight, but here says.
Mr. Bari,
Lordship,
if
Lordship,
Page-
kindly, one thing, Lordship, by, sees the page number 21, Lordship, that notification,
21 of,
no, 22 of this repetition, Lordship.
yes,
By that notification, state obstruct GTA to give appointment.
Yes, that notification
Subsequent,
gone.
yes, subsequently, in the appeal lordship, state changed their opinion and stated before the division bench that the GTA has power. Now the difficulty upon the GTA, initially they obstruct, the fund has to come from the state government.
yes,
We-
Mr. Bari,
we
there are two
little
things.
confused, Lordship.
If the ultimate aid is to come from the state
Yes,
government,
Lordship.
Yes,
without approval, concurrence of the
Yes,
state
Lordship.
government, nothing can be done.
my lord.
If the GTA is
I-
willing to
I-
bear all the
Yes,
financial
because-
responsibility and
because of the-
liability,
Because of the
it's
fact.
okay, there is no
Madam,
difficulty with
because of
regard
the
to that.
fact, Madam, your lords is absolutely correct. This argument was advanced and section 26 of GT Act. আরে এটা তো আমার কাছে থাকবো। give me.
Because the person, the authority providing the aid has to have control over this appointment.
এটা দিয়ে দিতে, মানে kindly excuse me, this marking portion is.
Yes,
there.
yes, that will help, Mr. Bari. I always love to have the marked copy.
Madam, section 26,
Yes,
section 26.
yes,
Subject to the provision of this act and any other law for the time being in force, any general or special direction of the government, the Gorkha territorial administration shall have administrative, financial, executive powers in the region in relation to. What relations? Now comes schedule 5.
yes,
The school education, including primary education, secondary education, higher secondary education, including vocational training, physical education, and government schools.
yes.
To show, well, this power was given by the act itself. So GTA is the responsible for releasing the cell. And it is being accepted.
Where is the fund of the GTA, from where it comes?
From state lordship, entire
Has
money
to-
has come from.
Has to
state
be
lordship.
from the, where is the, which section deals with the fund of the GTA?
Fund. কথাটা বলা আছে।
No, but in terms of this division bench
Yes.
judgment, you are bound to do this.
Yes, Lordship.
my lord.
So what have you done with this?
They have given the approval. The
So you are
division bench
bound by
judgment
this
was-
division bench judgment,
The
We have
division
not
bench judgment
challenged
was
before the
carried out.
Supreme Court,
then
we have no other option.
as per the GTA, it's for aided schools. They are,
no, but here,
no sanction is required.
no,
but only for-
paragraph 17, what is the effect of paragraph 17? Because it says the managing committee of the respective schools in conjunction with GTA must recruit the qualified.
Yes.
So fresh recruitment, it's not absorption, Mr. Bari.
No, fresh recruitment means, my lord, the further recruitment, whatever in future. But when it has already been, the judgment has, it has not got a retrospective effect.
No,
Well,
no, but Mr. Bari, there are two
GTM
aspects of the
regularization.
matter. One is regularization.
Yes.
If you say your initial appointment was not with the authority,
My lord, here,
then,
I
then
tell you, lordship,
absorption, whether you are entitled to absorption.
yes. Regularization, absorption is the same thing. My humble
Yes,
submission would
yes.
be before your
So
lordship.
absorption,
Now, my lord, it is,
process,
it
how
is
you are
not that the
recruited.
process was bypassed. because the act has been suspended in that area.
No,
To show,
there may be,
no, madam, what is the
School
alternative?
Service
mode?
Commission may not be.
Yes.
Because there are other recruitment processes where School Service Commission, I'm not talking about the education. So even then, mass scale advertisement and these things, procedures are to be made. So how this recruitment was made, once the recruitment was made, he will come up, kindly absorb me or regularize my service. Is it
Madam, that
permissible?
recruitment, I tell you, Lord.
Umadevi is a bar.
No, Umadevi now, man, it has sea change. The Supreme Court, recent 3 judgments have been delivered that the Umadevi was bypassed, and Umadevi said, Umadevi was considered in a later judgment. That I can show before your lordships. The question is there, my lord, today, your lordship
Is your prayer for regularization, absorption?
Yes, but that is there.
So, in this division bench judgment, this does not deal with that absorption of already appointed.
Well, that is the issue. Well, your lordship
But show me the finding with regard to, because in paragraph 17.
I tell your lordship, what is the single bench judgment? Your lordship kindly have a look at this. Your lordship kindly have a look at this judgment.
Single bench judgment.
Single bench.
So this was
appealed against. And not only one appeal, there are 4, 5 division bench appeal presided over by Justice Tandon, presided over by Justice Bharatdas. All appeals have been disposed of relying this division bench.
This division bench.
This division
has to be because
yes, because the
there is
coordinate bench. Coordinate bench.
170.
Now your lordship
yes.
kindly single bench judgment. Your lordship kindly have a look. Having heard the learned advocates for the parties and considering the contention of the paragraph 5-6 of the request which are quoted here under, that several orders were passed by the Honorable High Court for approval of appointment as a teaching staff of the different school in the district that who are working for a long period against the sanctioned vacant post. It is submitted the matter of Ravindra Rai versus State of West Bengal. The Rana Singh directed the authority to give approval to the appointment to all the candidates who are working as a usual and voluntary basis in their respective schools, and challenging the said order, the Rana Singh state authority prefer an appeal before the Honorable Court, being FM number. Stay was granted by the Honorable Division. Ultimately, state authority did not proceed with the matter, and same was withdrawn. Thereafter, all persons who are working in their respective schools for a long time have got their approval. In view of the aforesaid admitted position made by the respondent number 5 and 6 in the judgment, relied upon by Mr. Bari, learned advocate appealing for the petitioner, in case of state of Karnataka versus C. Lalita, reported in 2006 to SCC page 747. In case of a state of Uttar Pradesh versus Arvind Kumar Srivastava, reported 2015 once SCC, the petition being is disposed of by directing the respondent authority concerned to grant approval to appointment of the petitioner subject to fulfillment criteria eligibility of the petitioner for the post in question after following the procedure adopted as indicated in paragraph 6 of the affidavit in opposition within a period
What
of
is paragraph 6 of the affidavit in opposition?
or that is filed by the district inspector schools authority.
Yes, because
that
that
they have-
procedure was directed to be followed.
Yes,
What
one
is
of the
that procedure?
paragraph 6, it was said, I categorically mentioned when a section of the employee has given the benefit by the order of the court, whether he can be deprived. Paragraph 6 deals with, today I do not have the paragraph 6, deals with that we have given the approval in terms of the order of the court. If the order of the court, you have given a section of the employee, that has been quoted in all judgments, that you can deny the other persons who are similarly circumstanced. Now your lordships kindly have a look to this. This 1, 2, 3, 4, 5, 6 judgments dealt with by the several. So many there, but it is readily available. I have been given those. Justice Krishna Rao, Justice Vivek Rai Chaudhary, Justice Arindam Rai, Justice
Arindam
Mukherjee, all, several.
Yes, madam, what do you say to this?
No, so after
And
the-
state, who is for the state? What is the submission with regard to this?
So for the recruitment is also the relations of all unaided aided schools, not government. So for only in case of government schools, sanction is required.
So these are not government
No,
schools.
this is the aided.
Aided schools.
Government.
So aided schools,
No sanction.
no sanction is
That
declared.
is division bench exactly says so.
Jitya, what is the submission?
Lordship, after the division bench orders, have no option to accept their.
Now, my lord, may I now, my lord, intervene, my lord?
Well, a
To
stranger
bring-
cannot be permitted
To,
to.
my lord, bring your
Neither he is a
within,
party nor the-
within
He
2 days,
cannot
my lord, it
disturb
was
the court.
impossible for me to take out an application. But an FIR has been registered by the, my lord, Secretary Education Department, my lord,
That
in
is
respect
completely
of,
different. Who
in
have given
respect
the
of these
appointment?
teachers only, my lord. And my lord, the CID
the party
investigation
in
is
the
going
proceeding.
on. CID investigation is going on, which is subject matter of my writ petition, my lord.
Mr.
Well,
Ahmed, for what? For
in-
what CID investigation is going
My lord,
on?
in respect of the recruitment of these teachers.
Not these
These teachers.
Only these teachers, lad. And I must tell you, Lordship, lad, two of the writ petitions filed by the writ petition who has lad, withdrawn their writ petition from the principal bench. While lad, the court was proposing CBI investigation. One is
Where-
Shumon,
where-
one is
which
Shumon,
writ petitions?
one is Shumon Guru,
Petition, who-
Which writ petitions?
one is Shumon Guru. I have the orders of the High Court.
Filed by?
Item
Well,
number?
Shumon
That was filed before the principal bench.
filed before the circuit bench. It was subsequently transferred to the principal bench. Before the principal bench, all these issues was cropped up. Now the FIR of the Secretary Education Department was brought to the notice. Thereafter, court was proposing CBI investigation. After taking instruction, they have withdrawn the writ petition.
In which matters? In which matter?
Shumon Guru, possibly. Just a second, lad. List of our
Yes, item number 38. Who is appearing for 38?
Mr. Bari is appearing.
Mr. Bari, 38.
My
He
lord,
says that he was withdrawn from that.
this is one thing.
Have
lad.
you disclosed that in this writ petition?
No, it is not ever known. Someone who has filed the petition, it was.
He's
My lord,
saying, Mr. Bari, please take
But
instruction.
I have the orders. My lord, kindly grants
Yes.
me, my lord, kindly grants me 7 days time so that I can take out an application. I can bring to your lordship, my lord, all orders, all
Shumon
records.
Gurung, he says that he filed a writ petition before the principal bench, withdrew, and the court.
Apart from Shumon Guru, let other be.
I don't know whether that's Shumon Guru or I have no instruction.
Please,
Apart from Shumon Guru.
Mr. Ahmed,
Apart from
My lord,
Shumon
there
Guru,
are
let
two
other
writ
be,
petitions.
If they are there, apart from Shumon Guru.
this is
Well,
to
there-
see Mr. Bari, then the issues whether.
My lord, the
it's-
collusion
No,
is
no,
going
or
on, my lord,
Is there
between the
any-
blood.
Is there any information regarding other matters? Shumon Guru.
Yes,
may
yes,
not
yes,
be
sir.
accepted.
There are two matters I can let ascertain that one is Shumon Gurung and other is Milad. Just second let. And yesterday it was in the list. কোন কোন মর্ডার ছিল সুমন গুরুং আর কোনটা ছিল two writ petitions I shall keep the numbers just now I have this only Shumon Gurung's
All right,
number.
so you
all
that orders.
that I'm praying today, Milad.
Mr. Bari, please.
Kindly grants me
Mr.
7
Ahmed,
days
please
time.
supply the
Yes.
copy. Do you have a copy of the writ petition?
I have a copy of the writ petition also, Milad.
No, not this writ petition.
Suman, earlier,
The principal base.
name Suman Guru because the bunch of the
Now,
matters.
they ought to have
17
disclosed
matters
that.
were filed, Lordship. Matter was initially heard by the Honorable Justice Biswajit Basu. Subsequently, that matter was marked part heard and transferred to the principal bench.
You ought to have disclosed by him,
Name is-
by her.
I know their
In the first
name,
instance,
Suman
it
Guru.
was expected.
Name, whether this person, name.
Same,
I
you have a
need to
copy
check.
of that.
Lordship. If
Please
my
give it
office is
and the
kept-
orders passed.
Lordship.
Please give it to Mr.
Yes.
Bari so that
But
he can
all that,
check out.
all that I pray
The
today,
same,
Milad.
but I
That
have
is-
the copy.
Then let
All right,
Yes.
so maybe there may be similarity of the names, but the passes may be
Same
Dif-
person,
different.
same person that I have
Let me
ascertained.
check up
So
if that
let
is
Mr.
so
Bari
that-
check up, Mr.
Yes, yes,
Ahmed.
most
So
certainly, most certainly,
you can
most certainly.
supply the orders as
Yes.
well as the copy of the writ petition to Mr. Bari.
Yes, Milad. But kindly give me a 2 days time, so that I can take out an.
Tomorrow it can be, I am here.
No, Milad, by tomorrow it can't be done.
And the order, copy of the order. And
So that I
while
can add-
attachment is there.
So that I can
But
bring
it's-
Milad the
let's
FIR
I
registered.
want 1-2 days, because it's an old matter, Lordship, to 2023 or 2024
So,
matter.
2025. What are you saying?
Matters, Suman Guru, that.
Yes,
earlier
yes.
matter, Lordship.
Earlier matter.
I have.
Yes.
Petition is
No, no,
My lord,
but
and
there
my
is
kindly,
a-
kindly
there
direct
is
the
a-
state and my
even
GTA
though we
to
have
file a
doubt
short affidavit
about
so that
the
somebody can take
your lordship,
responsibility.
Let it be checked up.
Mr.
No, no,
Mr.
let it be checked up. Let it be
Yes,
checked
please
up.
check up.
I am the persons, your lordship knows that the suppressing the.
No, no, no.
That was.
That I don't say that
Bari,
lawyer.
If my client has done this,
It's not a question of that.
no,
The-
let it be kept aside. Let
Must
it
be
be
that
kept
the
aside.
It's
petitioner
not
has
about
not
lawyer.
disclosed before you
Lordship,
this
I have
fact.
the order
No, no, let
So-
it be kept aside. Your lordship kindly, if that will be, show my lord, I shall take it.
That there are matters I need to know.
Yeah,
I also
three
need a
matters your
copy of the
lordship kindly
petitions plan.
Lordship, I have the order copy now, Lordship.
No, no.
Sumangaram case.
She ought to
No,
have
no,
disclosed
No,
it
give a
first at the
copy of
first
the
instance.
petition, otherwise he will not be able to check whether that person is the same person or not.
Maybe same.
My lord, may I also
There
have
are-
a copy of the petitions
The
filed by the
fact
Mr. Bari?
is whether the issue raised in this writ petition was raised there. That is the most important part of that. One part is withdrawing and not disclosing that in the substance, that is one part. What was the issue there? If the
Yes, yes.
same issue is in the other matters, then it is to be
If it is
considered.
withdrawn, whether leave was given, whether my lord, they can be.
That is,
permitted.
so far as the
do not know.
petitioner is concerned.
I have no.
Now what happened in course of the hearing, as Mr. Ahmed says, that petition was taken
But
up. for
that
hearing.
apart, your lordship kindly put aside the Sumangaram case. Others, your lordship kindly let him say so.
Yes, yes. All the about others also, my lord. These 300, their names are appearing in the
Again,
list.
they are all political. I tell you, lord.
It's not political. It's a
They are
corruption.
330
It's a corruption.
corruption.
Mr. Bari must be fair.
Mr. Pari, when can you,
GTA
Tomorrow.
Not tomorrow is
Yeah.
difficult. Not tomorrow is difficult to bring on lordship's record, not everything. Lord. I need a one day time to file an application
Without filing an application
to
for
intervene.
party,
But
he makes the
it is expected that the
Mr. Pari,
GTA will.
only one thing, since this is the part that has to be taken only for the purpose of considering this. According to him, he is raising an objection with regard to a particular petition.
particular petitioner. Apart from
No, so
this,
for
but
that-
your lordship's kindly.
For
Not-
that, it
not
is to
for
be
particular-
considered.
Well, let it be. If it is not, it will be dismissed. It will be dismissed. No problem.
Wednesday, which day will suit
Well,
you?
it will
You can appear virtually.
Well,
Now,
that,
yes,
that will not be.
why?
I have experience.
Next
I-
week,
I
Monday,
have the
Tuesday,
experience.
Wednesday.
Virtual will not do. That's why I had to rush here.
But we'll go together. Lord.
Keep it tomorrow. Keep
Lord,
it
we'll go together with Bari Malad. I'll also go there with Bari Malad the next week. Lord.
tomorrow.
He wants to come with you.
No, no, no. It is very possible on my part to.
All right,
lift
Right.
let's appear tomorrow.
Don't keep it tomorrow, Milad.
let-
I want to bring on
or,
record,
or,
Milad.
or particular,
Difficult for
or
me.
I tell your lordships.
Lordship,
I tell your lordships.
Malad, I want to
Let
bring
it
on
be
record,
this
Milad.
matter
GTA has
be
to
posted
file an
next
affidavit,
week,
Milad.
Other matters tomorrow.
Milad, GTA has to file an affidavit. Milad, since I am
What affidavit?
He will
but
say
that
the
date,
GT will file
whatever
an
they are
affidavit.
saying on from the
Mr.
bar,
Ahmed, have you been appointed by the GTA?
Yes.
Milad, I am a Milad
So,
qualified
the
unemployed.
GTA is
Milad.
not praying for affidavits that you are saying they have to file.
Milad, what they are saying is Milad,
Mr.
contrary to the
Ahmed,
rec-
it's not your repetition.
No, Milad, all that I'm saying, Milad,
So,
all that I'm saying,
let
Milad,
the GTA,
GTA has filed their affidavit before this court.
Mr. Ahmed, GTA is represented by a
Malad-
competent advocate.
No, all that
So
I'm
she
saying.
will, she
No,
will,
all that
she will
I'm
take
saying,
steps.
all that I'm saying,
Hard
Milad,
Mr.
GTA has
Hard
filed their
Mr.
affidavit
Bari
before
Lanet-
this court,
Asu,
Milad,
Hard Mr. Bari Lanet advocate for the petition.
which is contrary to the Milad submission made by before the
Mr.
circuit bench.
Bari could not conclude his submission due to paucity of time. Yes, list this matter.
Hey,
tomorrow.
kalke chalo jao.
But before rising, 81 is the pension matter. Pension matter. Can it be?
Upgradation.
No,
Upgradation.
81 pension and persons retired, overdrawn after retirement, settled by
Mr.
Supreme Court.
Bari, today these group matters have been concluded. The other group is starting a bunch is the next matter. Starting from item number 45, I think it's in up to item number 75. Then from 76, that is one matter.
No,
It's a group
if-
matter.
if it is no
From
problem,
76 to 81.
Up to tomorrow, I am here. If your lordships kindly consider only one
Fix it
prayer.
for tomorrow.
81.
Who is appearing
Kalke.
for the other side?
It is appearing, my lord.
Who is the learned
I
advocate?
will inform. I will
You inform? I will consider.
Milad, my junior will be there tomorrow with all records, Milad.
Yes, yes. You can also come, Mr. Ahmed. It's a pleasure to hear you physically.
Mr. Bari is not allowing me.
Why? He's allowing. He's not stopping you from coming. He's saying not in the next week. He has not said, don't come tomorrow. It's a pleasure to hear you physically.
Lordship, may I request one thing? Lordship, kindly give us fixed time for this hearing, Lordship.
Fixed time for this hearing.
Lordship,
That is the most difficult part. Why?
Lordship, tomorrow I have some difficulty because I have
When?
after 3:30 because I have certain
Before
arbitration.
3:30 it will be done.
After 3:30 I have some difficulty, Lordship.
All right, that I will, you are the only advocate for the GTA.
Yes, Lordship.
All right, that I will.
Grateful, Lordship.
That's enough.